Please rise. The Chief Justice and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye. All persons having business before the Honorable Supreme Court shall give their attention, for the Court is now in session.
Are the cases in GR number 212426, Rene A.V. Sagisag et al. Versus Executive Secretary Paquito N. Ochoa Jr. et al. Et al. Petitioners in intervention. And GR number 212444, Bagong Alyansang Makabayan, Representative et al. Kilusang Mayo 1 et al. And Rene A.Q. Sagisag Jr. Petitioners in intervention. Appearing for themselves and as counsels for number 212426 are the following: Attorney Sagisag, Attorney Harry H. Roque Jr., Attorney Gilbert Terbel Andres, and Attorney Ethel Abisado. Appearing as counsels for petitioners, GR number 212444 are the following: Attorney Rachel F. Pastores, Attorney Ameline Sato, Attorney Sandra Jill Santos, Attorney Carlos A. Montemayor Jr., Attorney Maria Cristina C. Conti. Appearing as counsel for petitioners in intervention KMU et al., Attorney Remigio D. Saladero Jr. Appearing as counsel for public respondents are the following: Ruizo and Associate Solicitor in T. Hilbay.
Start, we'd like to manifest permission being given to Attorney Sagisag, who has requested leave to depart the proceedings at 5 p.m. and Attorney Harry Roque to leave at 3 p.m. Acting Solicitor General Florin Hilbay will now please approach the podium and commence.
Can you hear me? Okay. Justice, Honorable Associate Justices, good afternoon, and may it please the Court. For the benefit of the members of the Honorable Court, the petitioners, and fellow Filipinos who are following these proceedings, allow me to describe some highlight provisions of the EDCA and provide some. The EDCA is an executive agreement that implements the general principles of the Mutual Defense Treaty of 1951 and is the principle of defensive reaction in Article 4. Assistance in the case of an armed attack on in the Pacific area. The second is the principle of defensive preparation, found in Article 2, which states, in order more effectively to achieve the objective of this treaty, the parties separately and jointly, by self-help and mutual aid, will maintain and develop their individual and collective capacity to resist armed attack. Consistent with the principle of defensive preparation, the Philippines has a policy of entering into agreements that allow activities to promote that goal. The VFA, for example, allows into our territory equipment, materials, supplies, and other property, so they may conduct activities that promote the MDT's goal of maintaining and developing the capacity and collective defense. In Lim versus Executive Secretary, the Honorable Court declared, the VFA permits United States personnel to engage on an impermanent basis in activities, the exact meaning of which was left undefined. The expression is ambiguous, permitting a wide scope of undertakings subject only to the approval of the Philippine government. The sole encumbrance placed on its definition is couched in the negative. Personnel must abstain from any activity inconsistent with the spirit of this agreement, and in particular, activity. All other activities, in other words, are fair game. The court added, after studied reflection, it appeared far-fetched that the ambiguity surrounding the meaning of the word activities arose from accident. In our view, it was deliberately made that way to give both parties a certain leeway in negotiation. In this manner, visiting U.S. forces may sojourn for purposes other than military. As conceived, the joint exercises may include training on new techniques of patrol and surveillance to protect the nation's marine resources, sea search and rescue operations to assist vessels in distress, disaster relief operations, civic action projects such as the building of schoolhouses, medical and humanitarian missions, and the like. The court concluded both the history and the intent of the Mutual Defense Treaty and the Visiting Forces Agreement support the conclusion that combat-related activities, as opposed to combat itself, are indeed authorized. This policy of allowing activities is restrictive in the sense that any and all activities can only be upon approval of the 1 of the EDCA. This permission system is the core mechanism of the VFA, sustained by the Honorable Court in Vian versus Zamora, Lim versus Executive Secretary versus Romulo, and Arrigo versus Swift. The EDCA follows the VFA's policy framework. U.S. troops, personnel, equipment, material supplies, vessels, and aircraft. Access to agreed locations, which are facilities and areas provided by the government through the AFP. The general purpose is still the MDT's goal of maintaining and developing our capacity for individual and collective defense. Approval of the Philippine government. The EDCA is an executive. This is consistent with the representations of the parties. President Benigno Aquino III ratified the EDCA on June 6, 2014. In the case of the United States, it considers the EDCA to have entered into force on the 25th of June, 2014, as reflected in its diplomatic note of the same date. Finally, pursuant to the case Zablocki Act, which requires all international agreements entered into by the United States President to be filed with the U.S. Congress. Petitioners argue that the EDCA is a treaty couched as an executive agreement because it alleges first, under Article 2.4 of the EDCA, all facilities and areas that may be used and accessed are provided by the government of the Philippines through the AFP. Article 5 of the EDCA clearly states that the Philippines shall retain ownership of locations. By clear consequence of law, these agreed locations are not a situs of extraterritoriality. They are Philippine territory and Philippine property. Second, be permitted by the Philippines to construct and improve infrastructure in these agreed locations. The United States, however, will not be building in the concept of an owner. They will be building for the Philippines. This is because under the EDCA, all buildings, non-relocatable structures, assemblies affixed to the land in the agreed location or improved by U.S. forces remain property of the Philippines. States may be allowed both access and use of specific Philippine facilities and areas. At the same time, some of our facilities and areas will be restricted and consistent with our national security interests. Number one, such use and access will be for activities that must be approved by the Philippines. No prior approval, no access, and use of areas or facilities. Number two, such use and access must be on a rotational basis, intermittent. Number three, the government shall have access to the entire area of the agreed locations. Number four, the government shall retain primary responsibility for security with respect to the agreed locations. Number five, the operational control of the United States is limited to construction activities. Number six, the agreed locations will be areas of joint use, consistent with based on proportionate use of the areas and facilities as stated in the EDCA. These are indicators. These indicators are sufficient to make a reasonable person conclude that the agreed locations are not, will not, and cannot be converted into foreign military bases or foreign military facilities. With respect to foreign military bases or foreign military facilities are constitutionally required to be concurred in by the Senate. Because the EDCA involves an agreement Philippine military bases and Philippine military facilities, the EDCA need only be approved by the President of the Philippines agreement. This is because the improvement of Philippines and facilities with the principle of defensive preparation through the VFA. While the EDCA is a significant agreement, its purpose is entirely consistent with the MDT's concept of defense. Just as important, the EDCA is meant to improve the interoperability of Philippine and U.S. forces for every activity approved under the VFA. The EDCA simply operationalizes and articulates the details of existing policies of the Philippines established under the MDT and the VFA. The EDCA is an executive agreement by the standard of Commissioner of Customs versus Eastern because it involves adjustments of detail carrying out well-established national policies. The general features of foreign military bases, extraterritoriality, exclusivity in use, and foreign ownership are not present in these agreed locations. Read carefully, one sees in the EDCA the deliberate and successful efforts of the Philippine panel, all of whom are experts in their field, to ensure compliance with our Constitution. We demean their efforts by misreading the EDCA. By design or function, or by the standards of ownership, control, and use, these agreements cannot be considered foreign military bases or foreign military facilities. We consider the definition of a foreign military base, the general ability to define within the base the nature and scope of activities they wish to engage in. This general purpose license is found only in the former Military Bases Agreement of 1947, which gave the United States, quote, the rights, power, and authority within the bases which are necessary for the establishment, use, operation, and defense thereof, or appropriate for the control thereof, and all the rights, power, and authority within the limits of territorial waters and airspace adjacent to or in the vicinity of the bases which are necessary to provide access to them or appropriate for their control. This plenary ability, this general purpose license, is patently and demonstrably absent in the EDCA because of the permission system in place for every activity that will be undertaken by U.S. forces on Philippine soil as mandated by the VFA. The Philippines has control over these agreed locations not only because we own them, but also because we can set the parameters for their use and access by the United States through the permission system in place. By this control test, the agreed locations are decidedly Philippine, not foreign military bases. Under the EDCA, as with the VFA, the consent mechanism is individualized, ensuring that every activity will be limited in scope and duration. This type of consent mechanism is highly protective of Philippine interests because it provides the Mutual Defense Board and the Security Engagement Board real opportunity to scrutinize every detail that they authorize, develop a feedback mechanism for previous authorizations, and make sure that every activity fits a larger national or geopolitical context. This consent mechanism is dynamic, fluid, and responsive to varying security contexts as perceived by the current and future Philippine political and military leaders. This consent mechanism, this permission system, has been consistently declared valid by the Honorable Court in Bayan, Lim, Nicolas, and Arrigo. Let me take this opportunity to comment on some aspects of last week's hearing, especially with respect to number one, the notion of referring this matter to the Senate, and number two, the nature of petitioners' arguments as opposed to the government's submissions. With all due respect, Your Honors, a referral to the Senate will create multiple fundamental constitutional problems for the Honorable Court, the President, and the Senate. Number one, the Court cannot refer the EDCA to the Senate for consideration without preliminarily declaring EDCA unconstitutional for non-compliance with Article 18, Section 25. On the assumption that the Honorable Court does not dismiss the present petitions for lack of standing or other jurisdictional grounds, the question is whether the EDCA is an executive agreement or a treaty. And the task of the Honorable Court is either to dismiss the petitions or grant them. There is no middle ground. Number two, the Court cannot force a referral to the Senate without authority from the President. Only the President has the authority to refer international agreements to the Senate. Number three, the Senate cannot be compelled to accept a responsibility it did not seek or does not want to assume. In the context of separation of powers, the Honorable Court must understand the silence of the Senate to mean nothing less than a positive endorsement of the EDCA as an executive agreement and as an executive agreement that is good for the country. We ask the Honorable Court to consider the Senate's silence as a nuanced affirmation of the powers of the President. In the world of politics, silence has as much meaning as a screaming opposition. Number 4, a court-mandated referral to the Senate diminishes the powers of the President as Commander-in-Chief to act on matters that are within his prerogatives. The creation of a national defense apparatus and the determination of activities such as the improvement of military bases, prepositioning of defense materials, construction of military runways, barracks, and ports are core prerogatives of a commander-in-chief. Military activities are meant to consolidate decision-making in one person, the commander-in-chief. We should therefore seriously reflect on the wisdom of undermining this decision-making structure in favor of an intervention by the Senate, an institution that speaks with multiple voices. We should not impair the powers of our Commander-in-Chief. Now, perhaps more than at any other time, we need it to be as potent as it can be. The President, presentation for the United States that all internal requirements for entry into force of EDCA have already been complied with. A referral to the Senate contradicts this guarantee of the President. Number 6, a referral to the Senate is plain and simple delay. It accomplishes nothing positive other than delay and restricts the President's ability to respond to our manifold security concerns right now. Petitioner's argument against EDCA is not an argument for referral, but an argument against EDCA itself. On the assumption that this honorable court can overturn settled and fundamental constitutional doctrines and compel a referral to the Senate, a favorable action on the part of the Senate will simply bring us back to the Supreme Court. Petitioners will come back here and demand the nullification of the EDCA. We will be back to square one. The potential damage of such delay to our national security is incalculable. We invite the Honorable Court to look into the nature of petitioners' opposition against the EDCA. This is the 5th case, Your Honors, involving roughly the same issues, filed by essentially the same groups, with the same set of arguments. This is not to demean or belittle their opposition, because their opposition is vital to the operation of our democracy. Senator Sagisag, Dina Gabin, Professor Roque are eminent citizens of the Republic, and their advocacies are familiar to us. But there is a difference between political speech and a legal argument. A counsel for petitioners declared last week, quote, "For the United States, EDCA means enhanced defense capability of America," unquote. She added, quote, "To us, it means enhanced dependence of our country to America," unquote. This is a creative political statement. It is protected speech under the Bill of Rights, but is properly deployed for a rally in Mendiola or Plaza Miranda. With all due respect, this is not a legal argument. This argument will not survive a recitation in law school. It should not survive in a place as grand and beautiful as the session hall of the Supreme Court. For our part, what we have tried to do, Your Honors, is provide legal basis for every question raised against the EDCA. We have given Your Honors the case law, the exact language of the MDT and the VFA, clear standards for decision-making, and the various constitutional basis for the President's exercise of Commander-in-Chief, Chief Executive, and Foreign Affairs powers. Given these premises, we believe that our lines of justification are both clear and solid. Most important, They can be tested and falsified by the standards of reason and the tools of legal analysis so familiar to the courts of law. Allow me to end with a note on context. In an ideal world, we should have our own weapons, ships, aircraft carriers, missiles, spy planes, and military satellites. In a more ideal world, there is no need for an MDT or a VFA or an EDCA because there are no terrorists, there are no pirates, and every country respects each other's territories. But we do not live in that imaginary world. We live in a world where there are poor defenseless countries on one hand that have to balance funds for weapons and funds for school buildings, and economic and military superpowers on the other. We live in a world where the rule of law can sometimes be overpowered by sheer military might. That is the reality that we live in and the context in which we find ourselves situated. Our president has acted on the basis of the cards he's been dealt with. He has arranged those cards to the best of his abilities and waged our nation's future on the basis of that calculation. That is his supreme task as Commander-in-Chief, Chief Executive, and Chief Architect of Foreign Policy. In our democratic system, the Honorable Court, with all due respect, has no power to reshuffle those cards. Thank you.
Thank you, Solicitor General. Justice Garbo. Okay, Justice Leonen.
Good afternoon, Solicitor General.
Good
I
afternoon,
understand
Justice
that this
Leon.
is your first appearance before us as now the acting Solicitor General.
Yes, Your Honor.
Okay. It is clear to us that you want us to take a vote up or down regarding whether the EDCA is constitutional or unconstitutional. Is that correct?
There is another option, Your Honor. It is to
Dismiss.
dismiss the petitioners for lack of standing
Yes.
and other
But,
jurisdictional grounds.
With respect to the substantive issue in this case, you feel that it is constitutionally problematic for the court to do otherwise other than to declare it as constitutional or unconstitutional.
Insofar as referring it to the Senate, Your Honor.
Okay. But at any time, the President, in his political wisdom, may want to refer it to the Senate, but that is beyond the ken, in your opinion, beyond the competence of this court.
Yes, Your Honor. I suppose that if the President at some point changes his mind about the legality of the EDCA as an executive agreement and decides that it might be better as a treaty, then he might submit it to the Senate for consideration.
Okay. It is also your position that the negotiators, some of them are here present, I see, for the Philippines, I see Ambassador Ed Malaya in the audience, among others, have successfully gotten the United States to agree that all their movements of note or importance shall have the consent of the Republic of the Philippines.
In fact, Your Honor, activities should be pre-approved. If I may, Your Honor, the negotiating panel is composed of 3 lawyers and 2 non-lawyers. Yusek Pio Batino from the Ateneo
So you
Law
warrant
School.
before this court that the United States military will therefore get the consent for all their movements from the Republic of the Philippines.
They have no choice, Your Honor. As with the VFA, there is that core mechanism of pre-approval. It's a permission system.
I just wanted to make clear what the government's position was. Then, of course, you also say that we should read into the silence of the Senate. That according to you, this is a nuanced omission by the part of the
Affirmation.
Senate. Affirmation, yes. Is Senator Miriam part of the Senate?
Yes, Your Honor.
Yes, and it appears that she is not silent on this issue. As a matter of fact, just yesterday, she said that she's wondering why nobody from the petitioners have gotten in touch with her in relation to finding ways and means to call for Senate hearings on this issue.
I don't know why that is the case, Your Honor.
Or
but
is
what
his-
is important
or is Senator
for us,
Miriam's speech only political speech that we should not read into the silence of the Senate that you have mentioned a while ago?
That is a possibility, Your Honor.
Okay.
The fact of the matter is, no current member of the Senate is before us complaining about the impairment of their institutional prerogatives. In some cases, Your Honor, if I may remind the Honorable Court, what the Senate does is to pass a resolution authorizing certain members of the Senate to file the case. Here, you don't have that, and no individual or collective is here.
But I am sure that because of the representation you made today, probably tomorrow or the following day, some of the senators will make their positions known. And therefore, it is dangerous for us to make a reading of the silence of the Senate. But in any case, you are familiar with the case of Medellin versus Texas.
Yes, Your
And this
Honor.
has been cited in some of the cases that dealt with similar issues in this case.
Yes, Your Honor.
Is the VFA binding on the United States of America?
In the case of Nicolas versus Romulo,
No, I'm
majority of
asking
the
you,
members...
is the VFA binding on the United States of America? Just reading Medellin, regardless of the cases that we have in the Republic.
Your Honor, my strongest argument is a decision from the Supreme Court.
Which is?
Nicolas versus Romulo.
No, I mean, from the point of view of the United States, is the VFA binding?
Yes, Your Honor. In
Based on
fact,
Medellin.
in Nicolas versus Romulo, I think there was a note
From the point of view of
embassy.
the United States, this Nicolas versus Romulo is a decision of the Philippine Supreme Court. Medellin is a decision of the U.S. Supreme Court.
Yes, Your Honor.
Yes, and in Medellin, what was the ratio or the holding in Medellin?
But Medellin, Your Honor,
That
is
a
about
treaty
the...
is not enforceable in their jurisdiction until and unless there is domestic legislation to enforce it. Is that not correct?
As a general principle, Your Honor, but
Thank you.
the court in Medellin did not speak
Now you
about the
mentioned
VFA.
that there needs to be...
That's very different, Your Honor,
Yes.
if I may.
Thank you. Now you
you.
mentioned that in the EDCA, there will be no part of the Republic that will be ceded in terms of ownership of territory to the foreign troops. Is that not correct?
That is correct, Your Honor. No
In the
part.
military bases agreement of 1947, was there a cession of territory on the part of the Republic?
I remember, Your Honor, in Nicolas versus Romulo, Justice Ascuna mentioned that the United States bases were in fact not given to the Republic when the transfer of
That was
sovereignty.
flourish or rhetoric. But in legal contemplation, did we cede territory in 1947 to the United States of America in the form of Subic Naval Base, John Hay Air Base in Baguio, Clark Air Base? Were
They-
those considered American territory or were those only under the control of the Americans?
They were considered cituses of extraterritoriality.
But that did not answer my question. Were they still Philippine territory?
Again, Your Honor, consistent with the decision of Nicolas versus Romulo, in 1947, the Philippine bases were American territories.
The Philippine bases were American territories. So
That
in
is my
1947, the Republic of the Philippines conceded that there were portions of our country where Philippine sovereignty did not already exist.
My understanding, Your Honor, is that Philippine sovereignty did
I
not
hope that
extend
the
to those
Solicitor
spaces.
General can put this in the memoranda so that we have a formal
Definitely, Your Honor. Definitely.
and clear statement that under the 1947 treaty, military bases agreement, that we conceded territoriality to the Americans. By the way,
We will
the
articulate our
military
position.
bases agreement, was it treaty from the point of view of the Philippines?
Yes, Your Honor.
From the point of view of the United States, was it treaty
It was an international agreement, Your Honor.
from their point of view?
Yes.
Yes. In other words, we have the same situation that we have now with respect to the VFA, that it is considered as treaty in the Republic. And from our view, the U.S. is considering it as treaty in Bayan. But from the point of view of the United States in Medellin versus Texas, it is not treaty. Is that not correct?
That's not true, Your Honor. The decision
Of course
in
it is
Medellin...
in Medellin versus Texas, which was covered by both the dissenting and the main opinions in Nicolas.
Yes.
They were very clear about the holding of Medellin, and I had some researchers do a shepherd of that case.
Yes.
In the United States, it still holds. And as far as the United States Supreme Court is concerned, it is not binding on them until and unless there is domestic
I agree, Your Honor,
legislation.
but Medellin is very different. Medellin refers to the ICJ as a treaty. It doesn't refer to an international agreement entered into by the U.S. President in his commander-in-chief powers.
Let us see
Those
some,
are entirely
let us see
different
some
matters.
quotations from the decision,
Yes.
maybe later. But let me go to another point. What is your opinion of the Article 7, Section 21, which states that all treaties, no treaty or international agreement shall be binding unless concurred in by at least 2/3 of all the members of the Senate. Treaty is not ambiguous for many of us. But what is the position of government in relation to international agreement?
There are, consistent with standard practice, international agreements that may be submitted to the Senate and international agreements that need not be submitted to the Senate.
And standard practice being the practice of
The whole
government,
practice of the entire government machinery, Your Honor,
including
even
this
the
court.
decisions of the Supreme Court.
So international agreements are not treaties, correct?
Well, in terms of language, yes, Your Honor.
Yes, so there are certain kinds of agreement that has an international vinculum or relationship or consequence that are considered as international agreements but are not treaties. Is that not correct?
Yeah, that is true, Your Honor.
But it says here in the provision, there is no qualification in relation to international agreement. It says, no treaty or international agreement unqualified shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate. So does this mean that any agreement that has an international character must go for the concurrence of the members of the Senate?
No, Your Honor, that is not the practice of the Senate. That is not the
So how
practice
would
of
you,
the President.
what is your proposed definition of what international agreement is?
Just like in the United States, Your Honor, the determination
But
of
I'm
what
sorry,
is an-
we are in the Republic of the Philippines. In terms of the Republic of the Philippines and the Constitution, which our sovereign people fought so hard to promulgate, what is the meaning of international agreement in Section 21? I guess this is not from the United States. This is the blood, sweat, and tears of Filipino people that went to EDSA, that fought side by side with the Americans, fought for their independence. So let us not cite American jurisprudence to interpret our Constitution. But in any case, what does international agreement mean?
What I was saying, Your Honor, simply was that to some extent, practice in the United States can inform practice in the Philippines. And in the Philippines, Your Honor,
Also, we
there is an
follow what
EO
the United States will say.
No, Your Honor.
And therefore, we are still in that kind of precisely why the petitioners are here.
Your Honor, we are not saying
So
that
in
we
other
are
words,
following
what is
the
the
United
definition of
States.
international agreement, Counsel?
What I'm saying simply is some practice in the United States can inform our practice here.
Yes, what is the definition of international agreement under that section?
Pursuant to EO 459, Your Honor, there are certain international agreements that will be submitted to the Senate and certain international agreements that will not be submitted to the Senate.
What kinds of international agreements are not submitted to the Senate?
It's very fluid, Your Honor. It's really dependent
Wait,
on...
it's fluid based on what government wants, or is this a constitutional provision that is supposed to be interpreted according to you with the legality and the standards that are familiar to all lawyers in reading constitutional provisions? So by fluid, what do you mean?
It is fluid because it is consistent with the dynamics between the President and the Senate. And
So it
in
is
practice,
not
Your
something
Honor,
that we should intervene in terms of reading this provision in the Constitution. You mean to say that international agreement is anything that the President and the Senate will agree upon?
for the most part, Your Honor,
For the part that is not most,
Okay.
for the part that we need to be able to do, which is to rule on the interpretation of this phrase. What does international agreement mean?
Well, an international agreement, Your Honor, is really dependent on the characterization given by the President and the characterization given by the Senate.
So in other words, the meaning of international agreement is a political question which this court cannot rule upon.
for the most part, especially in the absence of a
What
disagreement.
about the part that is not part of most?
What I
Because-
would say, Your Honor, is that in a case where there's a Senate that is filing a case against the President, because the Senate says we disagree with the characterization of the President of whether or not this is an international agreement that is only an executive agreement, then you have a case that you can decide. But we don't have a case here, Your Honor.
Exactly, we have this case here where one of the parties are saying that this is a kind of agreement that should be ratified by the Senate. On the other hand, government is saying this is not the kind of agreement that should be ratified by the Senate.
We
So
have
again,
petitions,
counsel-
but we don't have a case, Your Honor. The case involves potentially
But
a
in order
disagreement
to
between the
resolve this
Senate and
question,
the Philippines.
Maybe you can allow me to finish the question. I am
Yes,
not
Your
here
Honor.
to debate
My
you, counsel.
apologies, Your Honor.
I am here to make clarifications from you because as far as we are concerned, we do have to make this decision.
Yes, Your Honor. My apologies.
So, to resolve the question as to whether this should be declared as constitutional or unconstitutional, we have to resolve the issue as to whether or not this is the kind of agreement that should go to the Senate or not go into the Senate. What would you suggest would be the standards for us to interpret this phrase, international agreement?
Thank you, Your Honor. In fact, the standards were given by Professor Harry Roque himself. He refers to Article 18, Section 25 as a lex specialis. To determine whether or not this is the kind of agreement that should be submitted to the Senate, the only thing we have to ask is whether this is a basing agreement or a facility agreement. That is a more focused standard, Your Honor, instead of a vague standard of whether or not it's an international agreement.
Is Section 21 part of the Constitution of the Republic?
Yes, Your Honor.
Yes, and therefore it plays a part in terms of whatever facts there are in terms of this case, correct?
That is true, Your Honor, but even the petitioner himself
And we have to
offers a
read
better
the
test.
Constitution in order to be able to arrive at a resolution of this case, regardless of whether or not it is the position of the petitioners or not. By the way, we have a great deal of respect for Professor Harry Roque. He is an eminent person in the field of international law, among others. But is he your authority in this case?
In fact, Your Honor, I adopt his theory for this particular question.
Okay. So that this is for Section 21, and I'm glad that you have come to agreement that you will now follow whatever Professor Roque will put in his
I didn't say that, Your Honor. What I said was, with respect to the application of Article 7 or Article 18, lex specialis rule applies. And
So,
Professor Harry Roque will agree, and I agree.
In other words, your consent to whatever Professor Roque will say is qualified.
Always qualified, Your Honor.
Always qualified,
Always.
yes. Now, let's go to the next provision, which is Section 25. Okay. If you look at the first phrase, it says, after the expiration in 1991 of the agreement between the Republic of the Philippines. So there is a timestamp in this provision. Would you agree with me?
Yes, Your
It
Honor.
says
That
after
is
the
true.
expiration in 1991. Then what comes next is the phrase, foreign military bases, troops or facilities shall not be allowed in the Philippines, correct?
That is true, Your Honor.
And it says, after the expiration of the agreement concerning military bases, okay, it says, foreign military bases, troops or facilities shall not be allowed in the Philippines. Let's take this step by step.
Yes, Your Honor.
Is the Mutual Defense Treaty basis for saying that the requirement here that foreign military troops or facilities should be allowed in the Philippines is because there is already a treaty called the Mutual Defense Treaty?
No, Your Honor.
No. So you are now conceding that the basis for the presence of troops and facilities in
Is the
relation to
VFA.
this section is not the MDT.
It is the VFA, Your Honor.
Okay, that's good. Now, with respect to the visiting forces agreement, you are saying that it allows the EDCA as an execution mechanism, as an agreement to implement the VFA. That's the full position of government.
Both the VFA and the MDT.
Oh, but you just said that in terms of Section 25, we do not need the Mutual Defense Treaty.
Insofar as, not that we don't need, Your Honor, insofar as allowing military bases, troops, or facilities are concerned, you cannot use the MDT because the MDT is a mutual defense treaty, and there is that provision in Article 18.
We'll just
But
focus on
insofar
Section
as-
25.
Yes, Your Honor.
So with respect to VFA, with respect to EDCA, for its constitutionality, you are saying that it is only the existence of the VFA that supports it.
No, Your Honor. The EDCA has certain aspects. Insofar as the presence of troops and their facilities are concerned, it is very clear that it's already allowed under the VFA. Insofar as all other activities that do not involve basing, trooping, or facilities, foreign facilities are concerned, you have the MDT for that.
The long and short of it, Counsel, what is the difference between foreign military bases and agreed locations?
Foreign military bases, Your Honor, as I have mentioned in my speech, are bases that have certain characteristics. Extraterritoriality, exclusivity in use, and most importantly, and ownership. Most importantly, Your Honor, we provided a test. The test is in the 1947 Military Bases Agreement. It's the general purpose license. It is that authority to determine the types of activities you can and want to do within the bases. That was in the Military Bases Agreement. You don't have that here, Your Honor. What we have in the EDCA, Your Honor, is agreed locations that are owned by the Philippines. We don't just control the perimeters. We have access to the entire locations. Constructions there will be operational control by the U.S. only for construction activities, but everything is ours. And that
In
is the
terms of
reason.
ownership, but in terms of control, you are saying that your position is that it gets the consent, every move of the United States military gets the consent of the Republic.
That is the system, Your Honor, under the VFA, and that is what the EDCA allows.
In 1991, there was a treaty that was proposed to the Senate. Do you recall that treaty?
Yes, Your Honor.
It was the 1991 Treaty of Friendship, Amity, and Cooperation between the United States of America and the Republic.
Yes, Your Honor.
Yes, and as a matter of fact, Senators Sagisag and Tanyada were a few of the senators that actually voted on that treaty. Correct?
Yes, Your
Yes, and of course, maybe to your knowledge, that there is a member of the bench right now, the Supreme Court, that participated in the actual negotiation of the 1991 treaty. Are you familiar with that?
Honor. Yes, Your Honor.
Yes. And in the 1991 treaty, it actually says, by the way, is the 1991 Treaty of Friendship, Amity, in relation to foreign bases, troops, or facilities, or foreign troops or facilities, because that is your position, the same as the provisions in EDCA?
The 1991 treaty, Your Honor.
Yes, in the 1991 treaty, there are provisions on troops and facilities, as well as the use of troops and facilities. Would you know if they are the same or similar to the provisions that we have now in EDCA?
My understanding, Your Honor, is that they are very different.
Very different. Okay. Let us look at this provision, Article 7, Defense Cooperation and Use of Philippine Installations, number 2, in the 1991 treaty, which was rejected by the Senate. Okay. The design of the treaty was that there was going to be a general agreement and there were going to be supplementary agreements. The third supplementary agreement was an agreement on the status of forces. In other words, the design in 1991 was there be a treaty of friendship first, which agreed to the installation of military bases in the Philippines or maintain its presence. And then as a supplement to it, because it is supplementary agreement number 3, there was an agreement on the status of forces. In other words, the status of forces would be the child and the parent would be the treaty agreement. Is that not correct?
My understanding, Your Honor, is that the 1991 proposed treaty simply extends the basing agreement.
Yes,
and
but
articulates
is the hierarchical structure accurate considering this provision?
Excuse me, Your Honor, sorry.
The hierarchical arrangement that you had a mother treaty and as a supplement to it is a visiting forces or a status of forces agreement.
But there's a very big difference, Your Honor. The 1991
No, let's just look at the
proposed treaty-
1991 first before we compare with the EDCA. Do you agree with me?
That what, Your Honor?
That
Sorry.
is the hierarchy under the
Yes,
1991.
yes, Your Honor, I agree.
But now it's the reverse. So you are now saying that the basis of EDCA is the visiting forces agreement. Is that not correct?
Both the visiting forces agreement and the mutual defense treaty.
Yes, but insofar as the existence of agreed locations are, the source now is the status of forces or the visiting forces agreement.
No, no, Your Honor, absolutely not. Nothing prevents the President as Commander-in-Chief under the MDT to agree to an agreed location. The only difference is
No, under
because
Section
we have the
25,
VFA,
you said that foreign military bases, troops, or facilities, your position is there are no bases, but there are troops and facilities, and these are foreign, and we can agree with that.
there are bases, Your Honor, but those are Philippine military bases.
Okay, but insofar as that provision is concerned, where it requires that there must be a treaty that allows it,
Yes, Your Honor.
your source is the EDCA, the VFA.
VFA insofar as the presence of troops and facilities are concerned. If
Yes.
I may give an example, Your Honor.
So
I think
in the
that
Treaty
this
of
will clarify-
1991, the framework was the agreement on the basis, and the status of forces was a supplement to it. On the other hand, what we have now is the reverse, that there is the VFA as a treaty, visiting forces as a treaty, and agreed locations in EDCA as an implementation. Is that correct?
With one very big and crucial difference, Your Honor. Under the 1991 proposed treaty, it simply followed the framework of the 1947 Military Base Agreement, which allowed the United States activities that they want to do within the bases. Here, Your Honor, what we have are Philippine
Supplementary
bases.
Agreement number 2, slide number 8. Supplementary Agreement number 2. These are the things that can be done inside. This is the 1991 treaty. And if you can see the highlighted portion, shall be subject to prior approval of the government of the Philippines. Now, your case is big on the issue that EDCA now gets all the consent of the Philippine government. Correct? But in the 1991 treaty, it is the same. And if
No.
you look at the listing now, it says training of U.S. forces, servicing, provisioning, maintenance, logistical supply, transit point for the U.S., projecting or operating U.S. forces. These are the list of activities that can be done in the 1991 proposed treaty with the United States, which was rejected by the Senate. And these are similar provisions to what is contained in EDCA.
Again, Your Honor, with one big difference. This treaty is a general license to do anything and everything. The only exception here, the only one that requires prior approval is paragraph E. In the VFA, every activity will be subjected to a consent mechanism. You don't have that, Your Honor, in the basing agreement, in a basing agreement. If I can give, Your Honor, an example just to clarify. The VFA
Article
forces...
3, agreed locations, paragraph 1 in EDCA. Okay. This is the provision which lists the kinds of activities. Article 3, paragraph 1. With consideration of the views of the parties, the Philippines hereby authorizes and agrees already. The agreement of the Republic is already in the EDCA itself, and it lists the activities. Isn't this the same as the 1991 treaty?
Exactly different, Your Honor. What you've read, Your Honor, is a general authorization of what may be done. These are the range of activities that may be allowed. But for every activity to be allowed, you have to go through the MDB and the SEB.
Where is this in the EDCA?
Everywhere, Your Honor, everywhere.
Can you
In fact,
cite
it's,
a specific location?
I think I have read that in my speech, Your Honor. In fact, here, it's in the preamble itself.
Oh,
This-
preamble, not in the body.
I will, if I may, Your Honor.
Can you read anything from the body
Recognizing-
which actually limits the section 1? Anyway, counsel, just to facilitate,
Article 3, paragraph 4, Your Honor.
which states that
The Philippines hereby grants to the United States through bilateral security mechanisms such as the MDB and the SEB. Right.
this is contrary to your position. Let us flash Article 3, paragraph 4, which is actually the point of the petitioners. We already granted them United States forces shall operational control of agreed locations for construction and authority to undertake such activities on and make alterations and improvements to agreed location to agreed locations. United States forces shall consult on issues regarding such construction, alteration, etc.
If I may give an example to clarify, Your Honor. Suppose we allow the United States to construct a runway. Will it make sense to allow them to have operational control for purposes of constructing the runway? Absolutely. Suppose we allow them to construct barracks for us. Will it make sense for us to give them operational control for purposes of constructing the barracks? Absolutely. That is a reasonable provision.
But isn't that the same in the 1991 treaty?
No, Your Honor. In the 1991 treaty, they can do whatever they want without permission. Why? Because the bases are theirs. They have a general purpose license to do whatever it is that they want to do. Here, Your Honor, every activity can be restricted and expanded based on the national interest of the Philippines.
Can you
And
point
that's a
to
very
a
different.
particular section in the EDCA that actually supports your position?
In fact, Your Honor, it's the preamble itself shows that all activities will have to go through the MDB and the SEB, recognizing that all United States access to and use of facilities and areas will be at the invitation of the Philippines and with full respect for Philippine Constitution and Philippine laws.
Okay. In relation to the VFA and the 1991 treaty, they do not mention the concept of a contractor. Can you enlighten us what the concept of a contractor is in the agreement in the EDCA?
Well, contractors, Your Honor, are private contractors with a contract from the United States military.
What is your position in relation to the petitioner's allegations that the contractors mean military contractors in the form of corporations like DynCorp or Blackwater, etc.?
It's very clear, Your Honor, in Article 2, paragraph 3. And I would consider this one of the strongest points for EDCA, the definition of contractors. United States contractors means companies and firms and their employees under contract or subcontract to or on behalf of the United States Department of Defense. United States contractors are not included as part of the definition of the United States personnel in this agreement, including within the context of the VFA. And therefore, they will be treated, Your Honor, as ordinary business people coming here to the Philippines. They cannot take advantage of the VFA, some of the immunities under the VFA, the VFA, which applies to military personnel. They will be treated as ordinary visitors and business people performing contracts in the Philippines.
Article 2 definition, paragraph 3, means companies and firms and their employees under contract or subcontract to or on behalf of the United States Department of Defense. So does this exclude the concept of DynCorp or Blackwater?
Your Honor, I don't think I have the authority to discuss what's written in popular for purposes of determining constitutional law.
Because there are indeed contracts entered to by the United States for this form of people call them mercenaries.
Yes, Your
To
well,
conduct
I don't know,
their
Your Honor,
activities,
whether they
or
are
security personnel.
I don't know, Your Honor, whether they are mercenaries, but I don't even know which kinds of contractors will be allowed here. But
And
if
as a
you're
matter
going
of
to
fact-
look at the EDCA, Your Honor, and its focus on construction of barracks and airports and ports and runways, I cannot imagine, how
Yes, that is a type of contractor, and of course, that is not the issue put into question by the petitions that have been filed in this case.
Yes, Your Honor, but those are not facts. Those are allegations based on books. These are popular books. Why we should indulge petitioners in their, in their fantasies about these things in the Supreme Court, Your Honor?
Because it's not a fantasy, because in Afghanistan, in Iraq, the United States did, in fact, engage a lot of contractors.
The fact that they were hired, but with respect to the activities of those who were hired, these are subjects of popular books, Your Honor.
So
This
is
not,
it the position of the government that the United States will never contract these security companies here in the Philippines in any of the agreed locations or for any of the activities mentioned in EDCA?
I don't know, Your Honor. What simply says
So it
here
is
is that the
possible.
United States.
So it is possible.
It is possible that the United States can
So there is
hire
there
because
also the
there's no
clause
limitation.
in Article 2, subparagraph 3, that these United States contractors are not included as part of the definition of U.S. personnel in this agreement, including in the context of the VFA.
And that is a good provision for us, Your
Yes.
Honor, because that does not give them any immunity. They're not
Yes.
treated as military personnel. They're
So
not
there
treated
are
as military
provisions in the
civilians.
EDCA whose, existence in law is based upon the provisions only of this agreement, because it says here that it does not flow from VFA.
The question, Your Honor, is whether or not the President as Commander-in-Chief can allow the United States or United States forces that are already here to hire contractors. I think that is properly within the general license of the Commander-in-Chief to allow a foreign military force already in to hire contractors so that they can build barracks, hangars, and ports. I don't think, Your Honor, that the military men themselves will build those barracks and ports. At some level, they will have to outsource to professionals to construct those runways, those barracks, those ports, those firing ranges, those training facilities.
Are we bound by this definition in terms of defining foreign troops in the Constitution? Are we bound by this provision which says United States contractors are not included as part of the definition of U.S. personnel in this agreement, including in the context
They
of the
are
VFA?
not troops within the contemplation of the Constitution. And that is exactly what the negotiators wanted, Your Honor.
So
and
if
they got
the
it.
contractors happen to be security personnel like Blackwater or DynCorp or some other corporation, and they hold guns and they patrol the agreed locations, is this possible? Or are you now telling this court that those things are entirely not possible?
Under the EDCA itself, Your Honor, we have primary responsibility because the location is ours and we have access to these locations.
Again, why was it that this agreement, why was it that it was not transmitted to the Senate by the President?
Because the President considers the EDCA as an implementing agreement following the general principles of the MDT and the specific rules under the VFA. For purposes, Your Honor, of the presence of troops and their equipment, supplies, and material, you already have the VFA. For purposes of construction of barracks and runways, what is so wrong about the Philippine President allowing a foreign force, if he doesn't have the funds, to construct those runways and barracks when they have joint activities?
The
Will that
petitioners
not-
are saying that there has been a change in policy from the military bases agreement and the mutual defense treaty to the VFA and then now the EDCA. And they are therefore saying that this change in policy colors the interpretation of EDCA in relation to the VFA and the MDT. What is the position of government in this regard?
Thank you, Your Honor, for for forwarding that issue. The policy of the United States to rebalance or pivot is not the kind of policy envisioned by Commissioner of Customs versus Eastern Sea Trading. The policy referred to or intended by the jurisprudence of this honorable court refers to the policy in the MDT, which is what? Defensive preparation. And the policy in the VFA, which is what? Allowing activities on a per-activity basis, allowing troops and their equipment, supplies, and personnel. That is the policy that we have here. That is independent of the policy of the United States, whether they are rebalancing or pivoting here in the Philippines. On the assumption that is true, what we have simply is a coincidence of military policies. But policies insofar as the constitutional question is concerned is the policy under the Mutual Defense Treaty, which is defensive preparation, that is a good policy, and the policy of allowing activities on a per-activity basis. That is also a good policy.
Okay. If we look at Section 25, it seems that the requirements are very clear. Section 25, Article 18, states that whenever there are foreign military bases, troops, and facilities, that it is best, according to the Constitution, that it is referred to the Senate because it is covered by a treaty and that it should be considered as a treaty by the other side.
If it is a foreign military base or troops or facilities,
Yes.
we already have the prior license, Your Honor, for the troops
Yes, but the
and their
difficulty
equipment.
is that we have a VFA, and the VFA is not considered as a treaty from the point of view of U.S. domestic law.
But the court has already decided, and the court must respect its own decision, Your Honor.
Counsel, in
In Nicolas
1898
versus Romulo.
Yes, in 1898, when Admiral Dewey's ships entered Manila Bay,
Okay.
the Philippine insurgents were already surrounding Intramuros. Is that not correct?
Yes, that is
Yes,
correct.
and instead of the Philippine troops going inside, the Americans told the Philippine troops, "We're going to do it for you." So they entered, had the fight with the Spaniards, and then entered into a Treaty of Paris where no Filipino was present. Is that not correct?
Yes, Your Honor.
Historically. Then in 1902, there was a Senate investigation in the United States led by Senator Cabot Lodge regarding the atrocities against the Filipino insurgents conducted by a certain general whose name is Hurd Smith, who was later on court-martialed and simply allowed to retire. This was done by the Americans, also with us. Is that not correct?
That is correct, Your
Yes. When McKinley came, prior to that incident, McKinley issued instructions to the Republic for the governance of the Republic of the Philippines. But he made sure initially that we were under the War Department, not under the Congress. Is that not correct?
That is correct, Your
Yes.
Honor.
In 1945, during the 1940s, during World War II, Filipinos bled with the Americans. And as they bled with the Americans, they fought the Japanese. Many Filipinos were killed. We suffered. Our ancestors suffered. And up till now, the veterans of that war are not considered were not considered and is not yet considered as having been in active military duty, and therefore do not get full veterans benefits. Is that not correct?
Correct, Your Honor.
Yes. And now we have the VFA, which we treated as a treaty, passed through the Senate, approved by the Senate because of the transmittal of the President, and in the United States, it is simply considered as an agreement. Is that not correct?
What is important,
Now we have EDCA, which is now produced again as simply an implementation of that VFA. Well, considering that light of history, the question that will probably be at the top of our heads is, why is it that the President simply did not assert that we have a Constitution, there is Section 25, there is Section 25 of Article 18, which requires that it be a treaty insofar as we are concerned, and a treaty in relation to the United States.
we shouldn't see every day, Your Honor, as an occasion for calculating historical pains. We need to move forward, Your Honor. In 2013, 13,000 U.S. troops assisted us in Haiyan. Imagine the risk and the cost of that assistance, Your Honor. We need to move forward, Your Honor, and see that every day is a possibility for a better future. Otherwise, we'll be impaired by pain and suffering. Also, Your Honor, our claim here is not that the Constitution should be violated for the President. Our claim is rather straightforward. The President is correct when he says that the licenses for the presence of troops and their equipment are already here, that he has the authority under the Constitution and under the MDT to improve our military bases and facilities.
But it could have been clearer, and therefore no cause of action would have been, as you said, it would
I
only be
doubt it, Your
political
Honor.
arguments.
I doubt it, Your Honor. It's clear.
If the executive would have just simply crafted EDCA, and because it is such a good agreement, it is such a fine agreement, it creates a new theory of consent for every military movement of the United States, and now equalizing, according to you, the relationship of the U.S. and the Philippine military forces, that it would not have been possible for the Senate not to see how good an agreement it was. Instead, the executive took the risk of actually having this court to decide on whether the EDCA is international agreement or not, or whether it should be treaty or international agreement.
Your Honor, we should allow the President to determine the boundaries of his own power.
Yes, but the
The
boundaries
President
of the
has
power
made-
of the Commander-in-Chief is always bordered by the provisions of the Constitution.
That
Wouldn't
is
you
true.
agree with me?
That is true.
Yes. And in
That is
terms
true.
of reading Section 25, Article 8, are you saying that we have to have full deference in favor of the interpretation of the executive?
Because the executive is correct, Your Honor. All the previous licenses have been secured. What else do we need? That is the position of the President.
Military
And the President
contractors, agreed locations, the provision in the EDCA which actually says that the purpose is such other purposes as
Yeah.
may be agreed upon by the parties, which is open-ended.
that is consistent with the VFA,
The
Your Honor.
risk that the EDCA puts us in terms of any action that is either defensive or aggressive of the United States in
Our
the
policy in
Pacific.
the Constitution is defensive, Your Honor.
Yes, but in cases of the EDCA, it says that the operational control over
For
the facilities
construction activities, Your
and
Honor.
over the pre-positioned material.
I don't think, Your Honor, we will get into war if a runway is constructed with the assistance of
the United
States
States, of
government.
course, is taking care of its troops that is stationed in the demilitarized zone between North Korea and South Korea. Is that not correct?
That's true.
The United States is looking at the activities across the straits between China and Taiwan. Is that not correct?
That is true.
And then, of course, the United States is looking at the activities or the build-up of China in terms of its military facilities. Is that not correct?
I suppose that is true.
And of course, it is not only the state actors, but the United States is also taking a look at, as we are, with activities of terrorism that is coming from all over. Is that not correct?
That is correct, Your Honor.
And it is possible that any of the facilities that are in the Philippines would be used for any of those purposes, whether covert or overt, or for whatever purposes whatsoever.
In the decision in Lim, Your Honor, the court already held that combat-related activities are allowed.
Yes.
And that is standing jurisprudence of this honorable court.
Yes. My point is, this is such an important foreign policy that the vision of the Constitution is that it will be shared with the President, because it is said that foreign military bases, troops, and facilities will only be allowed if there is a treaty. Can that not be the reading of the Constitution?
That is, in fact, the reading of the Constitution. And what we're saying, Your Honor, is
In
that
fact, this
insofar
court can be
as
very
troops,
deferential. It can actually say whatever the President says and the Senate agrees upon in relation to foreign bases, because it's not prohibited, in relation to foreign troops, in relation to foreign facilities, should be allowed. But by God, it says in the Constitution that it is not only the President. There has to be a treaty, and that it is a treaty also of the other party.
if it is a foreign military base or a foreign military facility, we have already shown you, Your Honor, all the indicators like that a reasonable person will probably accept
Again,
as...
Counsel, the Military Bases Agreement of 1947 was ratified as a treaty in the Philippines, correct?
Yes, Your Honor.
And in the United States, it was not ratified as a treaty from their perspective. It was signed only and treated as an executive agreement.
And according to the jurisprudence of this honorable court, that's more than enough so
And
long as they
according to
recognize
the
it as
Constitution
a
of
binding
of
agreement.
1987, because of that, in the deliberations of the Constitutional Commission, because of that, there was Section 25. And they insisted in the clause to be treated as treaty by the others. Now you have VFA.
That is a dissenting opinion, Your Honor.
VFA.
That is a dissenting
No,
opinion.
I'm not mentioning the dissenting opinion. I am mentioning dissenting opinion of Justice Carpio, by the way.
Yes, Your Honor.
Uh,
And we have to recognize it for
who
what
is
it
a
is.
sitting
A
member of the
dissenting
court,
opinion.
Who is a sitting member of this court.
Yes, Your
Yes.
Honor. We
But
recognize
in any
that.
case, I'm not referring to that opinion. I'm referring to that situation, and therefore, the motive behind Section 25 of Article 18. But now we end up again with VFA, which you said is the basis for EDCA.
Yes, Your Honor.
Yes. Thank you, Counsel.
Thank you, Justice Leonet.
Justice Carpio.
Sorry.
One of the islands that we hold in the Spratlys is Pag-asa, correct?
Yes. Your Honor.
Under the baselines law, that is part of Philippine territory, correct?
Yes, Your Honor.
Can one of the agreed locations under EDCA be in Pag-asa?
Okay. Your Honor, the decision to determine an agreed location is a highly constrained decision. The United States will have to make its own calculations whether or not that makes sense based on their interest, and we will have to make our own calculation whether or not that makes sense based on our national interest. In terms of possibility, anything is possible, of course, but that possibility will have to be filtered by the realities of our national security and the United States national security
Okay.
concerns.
We consider Pag-asa as part of Philippine territory. Does the U.S. consider Pag-asa part of Philippine territory?
I'm not exactly sure, Your Honor, but I can provide you with a more
The
authoritative...
U.S. has said again and again that they do not take sides in territorial disputes in the South China Sea, in particular the Spratlys. So they don't consider that as part of Philippine territory.
They can always change their policy, Your Honor. They can
So
always
you are
reinterpret.
saying that under EDCA, the Philippines can propose that one of the agreed locations be in Pag-asa? Is that what you're saying?
Your Honor, within a very large universe of possibilities, I can imagine that to be a possibility. But that's a very large universe of possibilities.
Okay, let's go. You said that the EDCA implements the MDT, correct?
Yes, Your Honor.
And the core of the MDT is that an armed attack against one country is considered an attack against the other, in particular against the metropolitan territory of one country, correct? Second, against an island territory under the jurisdiction of one country, correct? And against a public vessel or aircraft of one party, correct?
Your Honor, our position is that the EDCA has the MDT has two important principles. The first one is what you mentioned, the principle of defensive reaction. That if we are attacked, then we can invoke the treaty so that the United States can determine its own constitutional processes for reacting. The other is, and it makes a lot of sense, defensive preparation. We have to
I know
prepare.
that. My question is, I'm just asking for your confirmation.
Yes, Your Honor.
Under the MDT, if, for example, an island territory under the jurisdiction of the Philippines is subject to an armed attack by a third state, we can invoke U.S. help under the MDT, correct?
That is true, Your Honor.
Okay. In 2012, China seized, through overwhelming armed force, Scarborough Shoal, defined under the baselines law as part of Philippine territory. But the U.S. said, oh, that's not covered by the MDT because that is a disputed territory. Is that correct?
I think, Your Honor, that is what happened.
What?
Your Honor, that is what happened, I think.
My question is, who is correct? The Philippines saying that that is part of Philippine territory and that's never been disputed, or the U.S. that it is disputed territory?
The MDT, Your Honor, is a bilateral treaty. I suppose at some level the Philippines and the United States will have to agree as to the definition of our territory
So
for
what are
purposes of
the,
invoking.
let me ask you, what are the island territories under the jurisdiction of the Philippines that are covered by the MDT? We should know that.
Yes, Your Honor, we know that, but that is only one part of the other part of the equation, Your Honor, is the United States
Yeah,
understanding.
my question
of the
is,
territory.
does the Philippine government know exactly what are the island territories under its jurisdiction that are covered by the MDT?
Yes, Your Honor. of
We know.
course, yes.
Can you submit a listing of all of these island territories under the jurisdiction of the Philippines that are covered by the MDT?
I suppose, Your Honor, we can do that.
You can do that. Remember, the Philippines is composed of 7,100 plus islands. All are islands. So they are all island territories under the jurisdiction of the Philippines. But the U.S. said Scarborough Shoal is not correct. That is the
true.
position of the U.S.
That is true, Your Honor.
Okay, let us say there is an island in Palawan, in the West Philippine Sea, called Sema. If China says, oh, that is a disputed island, we are claiming that also, is that now taken out of the MDT?
Again, Your Honor, it will have to depend on the actual circumstances.
Yeah, the circumstances are, China says, Sema Island is part of China, indisputable territory of China. So they occupy it, we MDT, the US says, oh, that is a disputed territory because China is claiming it. Who is correct, the US or the Philippines?
Well, again, Your Honor, because this is a bilateral agreement, I suppose we can complain, right, about the violation of the treaty by the United States. But again, I hope, Your Honor, you understand my hesitation in making any statement that might have some diplomatic consequences given that I am the agent for the Philippines.
I just want to know what are the island territories under the jurisdiction of the Philippines that are covered by the MDT. That's basic. We have
will
to know
submit
that.
We will submit that, Your Honor.
You will submit a listing
yes,
of that.
Yes, Your Honor.
Now, there is a decrepit warship in Ayungin Shoal. It's called the Sierra Madre. It's manned by about 2 platoons of Marines. And let us say the U.S. said that's part of the disputed territories in the West Philippine Sea, correct? Ayungin Shoal?
Yes, Your Honor.
But we have a vessel there, Sierra Madre,
Okay.
under the roster of our active warships. What if that is forcibly seized by China? Can we invoke the MDT?
If our president decides to invoke the MDT, I suppose he can.
Would the Americans come
Your
to our
Honor,
aid?
I'm not here to speak for the United States. I'm here to defend a very particular agreement.
So
the
there is no
EDCA.
guarantee, in other words, that the Americans will come to our aid if we invoke the MDT. That's what I'm asking.
That is a bilateral agreement, Your Honor. They can have their own interpretation of our agreement that is opposed to our own interpretation.
Yes.
That is the reality of life, Your Honor.
That is
It
exactly
happens
what
every day.
happened in Scarborough Shoal. We said Scarborough, if you look at the maps, since the time of the Americans here, it's part of Philippine territory. Now they say it's disputed territory, so we cannot invoke the MDT. So it really depends on America whether they want to come in or not, correct?
Well, I suppose that is consistent with everyone's.
So what is the
interpretation
value
national
of this
interest.
EDCA MDT
Okay.
if there is no guarantee of assistance?
The value of the EDCA, Your Honor, is in terms of a lot of things. Number one is it actually assists improve Philippine military bases and Philippine military facilities, consistent with the training programs that we have in the in the VFA. If I may give an example, Your Honor, the United States come here for
So
a
in other
three-week
words,
visit.
EDCA will help us improve our facilities, but it doesn't give us any guarantees that in case there is an armed attack against the Philippines, the U.S. will come to our aid. That's the bottom line, correct?
There is no guarantee about the future, Your Honor. If we study world history, in World War I, World War II, a lot of commitments were broken. There's no guarantee.
There's
But
a guarantee.
what is important with the EDCA, Your Honor, is that it entangles the United States
And the latest,
with the interests of the Philippines.
In the latest
That is
example
good.
of there is no guarantee even if there's a security arrangement is in Crimea, where the U.S., USSR, and Great Britain in 1994, December, signed a memorandum of defense assuring Ukraine, if it gives up its nuclear weapons, the US, Russia, and UK will guarantee the territorial integrity of Ukraine. This year, Russia invaded, seized Crimea, incorporated it into Russia. The US did not even send any arms. Britain did not send any arms. So that is the kind of guarantee that we face in this world, correct? We cannot depend on third countries, on other countries, to defend ourselves, correct?
We need to defend ourselves, of course.
Yes. In other
But-
words, you agree with me, Counsel, that for purposes of our own defense, we can only rely on ourselves, correct?
Well, we have to rely on ourselves because there's no other choice but to rely on ourselves. But nothing prevents us from taking advantage of existing alliances.
Yes, but that is no guarantee, as you said.
Of course, Your Honor, there's no guarantee.
Yes, so there is no guarantee at all. The latest example is Crimea. Despite a guarantee by the U.S. guaranteeing the territorial integrity of Ukraine if it gives up its weapon, because when the USSR broke up, a third of the nuclear weapons were located in Ukraine. So they wanted Ukraine to give that up, and they promised Ukraine, we guarantee your territorial integrity. This year, Russia seized Crimea and incorporated it. So there is no guarantee. The only guarantee is your own self-defense, correct?
Yeah, I'm here to defend the EDCA, Your Honor,
Yes,
not to
but I
blame
want-
a superpower or anything
Yeah,
like
but I
that.
don't want you to tell the world that we can rely on EDCA for our defense. Is that correct?
Absolutely not, Your Honor. We're not starry-eyed in saying that EDCA will save the country from all its problems. What we're saying is that this helps. This helps improves runways, barracks, training facilities, ports, those matters that are related to the training exercises between the Philippine and
Yeah,
U.S.
it
forces.
just helps us improve our equipment, our bases, but when the showdown comes, when China attacks, the U.S. doesn't necessarily be there, correct?
The goal, Your Honor, is to prevent a showdown because
You are
God knows what
saying
will
that the
happen.
EDCA will prevent a showdown. Is that a guarantee?
No guarantee, Your Honor, but
No
this
guarantee.
helps. This
Yes.
helps, Your Honor.
Yes.
Either, Your Honor, we have to live in the real world. You know, we have limitations, and you know,
Yes, we
people
live
who
in
are
a real
reasonable-
world, Council. That's why we lost Scarborough Shoal despite MDT.
And we learn
Correct?
from that, I suppose. We learn from that. We have to learn from that, Your Honor. And this might be a response to that context.
No, you're saying that this is our response, EDCA, to prevent another Scarborough Shoal incident?
What I'm saying, Your Honor, is that this might be part of a whole range of responses of the President as our Commander-in-Chief. You know, Your Honor, these are military matters. I am not an expert on military matters. I don't think a lot of people are experts on military matters, but if there are experts on military matters, that would have to be the Department of National Defense. If there are experts on diplomacy, that will have to be the Department of Foreign Affairs. My goal, Your Honor, is to defend the constitutionality of an agreement. That is all.
Okay,
I'm
but
not
I
here
just want you to understand,
like a
Council,
Santa Claus,
that
you know,
even if
bringing
we
gifts.
declare EDCA constitutional, it doesn't mean that there will be a guarantee from the U.S. that they will defend us, because there is no such thing as a guarantee, correct?
Of course, Your Honor, there's no such thing because I cannot predict what the United States will do. But we have here a real action from our Commander-in-Chief. He has done something. Let us help him. Because
Okay,
the
the
cost
US
of doing nothing is incalculable.
Okay. the U.S. said that they will not take sides on territorial disputes in the South China Sea. So that's an advance, they are telegraphing to China that if you seize Pag-asa, we will not take sides. Is that correct?
They can always change their mind, Your Honor. I cannot predict what the United States will do.
But that is
will
what they
say
said.
tomorrow.
That is what they said.
That is what they said
They told the
several
world.
months ago, Your Honor. That is
So
what
you
they
are
said.
hoping that the U.S. will change its mind and defend us if China invades Pag-asa?
We do what we do what we can, and let's hope for the best. That is all, Your Honor. That is the reality.
If you were the military advisor of the U.S., of the Philippines, of the president here, would you tell him that there's a possibility that the U.S. will change its mind and defend us in Pag-asa? Would you
Your
say
Honor,
that?
I am unqualified to make a military advice for the president. I'm totally unqualified.
Common sense
for that.
advice.
I don't even know what common sense means in the context of, military diplomacy, geopolitics.
So it is not common sense to say that since the U.S. said that they will not take sides in disputes in the West Philippine Sea, they will not come to our aid if Pag-asa is invaded. It doesn't make sense.
Your Honor, reality is very complex. Things change.
So you will
it's
hope
very
that the
difficult.
U.S. will come to our aid. The cavalry will arrive in Pag-asa Island.
Hope is free, Your Honor, and so we might as well have it. Right? But we do what we do what we can. And that is EDCA, that is the VFA. We also have the MDT.
Okay, Counsel, thank you.
Thank you, Your Honor.
Justice De Castro.
Counsel, let's go back to trying to understand why there were agreements between the U.S. and the Philippines where the agreement was submitted by the Philippines to the Senate while the U.S. Did not do that but considered it as an executive agreement, which is within the authority of the President of the United States. Now, this agreement that we entered into with the Philippines, they did not pay any rent for the use of any...
Under the EDCA, Your Honor.
No rent. No,
Under the EDCA.
even in the Treaty of Friendship and Cooperation, which was rejected by the Senate, there's nothing about compensation to be given to the Philippines.
I will check, Your Honor.
Also here, in the BFA, there is no compensation. In the BFA, we waive criminal jurisdiction,
Yes.
but the U.S. did not waive criminal jurisdiction.
Your Honor, there are jurisdictional rules in the VFA.
Yes,
We did not waive.
It's a matter of
jurisdiction.
fact that the Visiting Forces Agreement, it is only the Philippines which waive criminal jurisdiction. There is no reciprocity.
Well,
We also-
that makes a lot of
Yes.
sense, Your Honor, because they're the
Yes,
ones
yeah,
visiting.
I'm not trying to find the justification or
Okay.
rationale behind it. Let's just look at it as a matter of
Okay,
fact.
Your Honor, my apologies.
We gave tax exemptions.
Under the
We,
EDCA? Your
under
Honor?
even the Visiting Forces
Your
Agreement.
Honor, under the EDCA, it's tax
No,
assumption.
it's also tax exempt here in the EDCA.
Tax assumption, Your Honor. We do not consider the United States tax exempt. We will simply assume those taxes, meaning that the Philippine government
Will
will
pay.
pay for the
Will
taxes.
assume.
If I may give an
Okay,
example.
all right, that's not material to what I'm trying to drive.
Okay, Your
at.
Honor.
We also exempted them from immigration rules.
That is true, Your Honor.
So in this agreement, it was the Philippines that was giving concessions, even to the extent of having our laws amended, so that we can accommodate the U.S.
Your Honor, the Visiting Forces Agreement allows activities that train Philippine forces. And so this is highly beneficial for us because we don't have the technology, we don't have the funds, and so the visiting forces...
Let's not go to the justification or reason
Okay.
behind it. I just want to know if you agree that we gave tax exemption, we
That is
exempt
true.
them from immigration rules.
That is true.
We did not
Yeah.
ask them to pay rent. We waived criminal jurisdiction, but they did not waive criminal jurisdiction, which means that They are on the receiving end. We are the ones giving concessions to the US. And because of that, there is no need for them to go to the Senate for concurrence. There's no need for a treaty because everything that they entered into in the agreement with the Philippines would only involve all the constitutional prerogative of the US President as Commander-in-Chief of the Armed Forces.
That is true. That is true, Your Honor.
Oh, that's why.
That
That is
is
the reason why they say the agreement, even if it was not submitted to the US Senate,
U.S. Senate.
is a binding international agreement because they did not go beyond the presidential authority under the US Constitution. Whereas in our case, we were conceding the implementation of our laws, the non-implementation of our laws insofar as the US and its personnel are concerned. So
That
we
is
we need a treaty for that.
Insofar as the VFA is concerned, Your Honor. Yes, that is true.
All right. So that is the reason why they keep on saying that this agreement, even if it was not submitted to the US Senate, is
US
binding
That is true.
because
Yeah.
they did not concede anything that will require the enactment of a US law or which will require the
implementing law.
intervention of the US Congress. But
That
it
is true.
It is different in our case. We are waiving criminal jurisdiction. Jurisdiction over criminal cases committed in Philippine territory. We're waiving that. So we need a treaty to be able to do that.
Yes, Your
And
Honor.
so even the BFA, which contains a provision on the waiver of criminal jurisdiction, we had to submit that to the Senate.
That is true, Your Honor.
But it was not, there was no need on the part of the US to do that
I agree. I agree,
because
Your
there's no
Honor.
reciprocity.
Insofar as that portion is
Yes,
concerned. Yes.
So now let's look at the EDCA.
Yes,
Now,
Your Honor.
the Visiting Forces Agreement, the constitutionality of that was submitted to the Supreme Court, and I was already here when that was decided. And I concurred with the majority opinion upholding the constitutionality of the BFA.
Yes, I know, Your
And
Honor.
the reason is that it was understood that the presence of military personnel or military troops in the Philippines will only be temporary.
Yes.
So the BFA speaks of the term sojourn, temporary,
Visiting.
temporary presence of military troops, U.S. military troops in the Philippines. Now, can you say the same thing of the EDCA? Will there be?
Exactly, Your Honor. Insofar as the presence of troops are concerned, the license was secured from the VFA. And so, Your Honor, the mechanism for allowing the presence of U.S. troops here in the Philippines is exactly the same mechanism as in the EDCA. And so the EDCA is derivative of the VFA insofar as the presence of troops and their equipment, supplies, and materials are concerned. And so the license has already been secured.
Will that be the same as the BFA if, as the EDCA now would allow the construction of non-relocatable structures in the agreed locations? So there will be permanent structures in the agreed location which will be owned by the U.S.
By the
and which will be
Philippines.
under the control of the U.S. Now, if that will be under the control of the U.S., who will man these structures?
The Philippines, Your Honor. If I can give an example, one of the problems that they have with respect to the Visiting Forces Agreement is that the Americans don't really have a place to stay when they come here for the balikatan, the FIBLEX, or the karat exercises. What we will do under the EDCA is we will allow them to build those barracks so that then when they are here, they can take advantage and use those barracks. They will have access. But once the 3-week engagement is over, once their visit is done, the Philippine forces can use those barracks. The same thing is true with mess halls. The same thing is true with runways, which is why we're saying that this is good for the Philippines. And there's no requirement for securing the consent of the Senate because what is being improved are Philippine bases and Philippine facilities. And that is the the simple explanation, Your Honor. They will be building those runways that will be used by the Americans when they come here. We can use those runways. Be building those barracks. Every time they're here, instead of staying in their ships, they can go to those barracks, and then they leave again. And then we can use those barracks. The same thing is true with mess halls and ports. All of those construction activities, Your Honor, are construction that can be done by the Philippines if we had the resources. But the reality is that we have to balance our resources because funds for barracks and runways can be used for the socioeconomic projects of the legislature and the president. Here, what we're saying is we will allow the United States to improve those facilities, our bases, and when they leave, we can use them. Insofar as title to those properties are concerned, they are ours. That is why we have access to them. That is why we have primary responsibility for security, because the bases are ours. The facilities are ours. This is very different from the military bases agreement where you carve out a portion of territory that will be United States jurisdiction. We might have control over the perimeter, but they will have control over what they can do inside the bases. That is clearly not the case with the EDCA, Your Honor.
Preposition the material and the storage of defense equipment and other supplies.
Yes.
How long will they stay in the country, in the agreed location? If this is for storage and for prepositioning, can you still say that they will stay here temporarily in the same way that you say that the troops will come and go?
It will have to depend, Your Honor, on the nature of the material, I suppose, and on the security interests of both the United States and the Philippines. And so we cannot provide a specific answer because we need to have the context first before we can say how long those humanitarian assistance and disaster relief materials will have to be prepositioned right before a calamity. We don't know, Your Honor.
Oh, well, do you agree that unlike the BFA, we now here have the term storage, prepositioning, which are not envisioned in the BFA?
That is true. That is true, Your Honor. But the storage and prepositioning are activities that the President as Commander-in-Chief can do on his own. He doesn't even need the MDT to do that. He can do that as Commander-in-Chief. If he wants to store humanitarian and defense disaster relief materials, he can do that on his own without any treaty. If he wants to store weapons or stockpile ammunition, he can do that on his own as Commander-in-Chief. But there are limitations on our resources. And so what we will do under the EDCA is to allow the United States, if they want to and if we agree to it, to preposition defense and humanitarian assistance and disaster relief materials.
You say that we will own the facilities, we will
Yes.
own the agreed location,
Yes.
but can you not consider that as naked ownership because it will be under the control of the U.S.? What kind of ownership is that?
Your Honor, the control of the United States is only for construction activities. Once the construction is done, the facilities are ours. That is by clear provision of the EDCA. If they construct a runway, that runway will be ours. If they construct barracks, those barracks will be ours, but they will be subjected to joint use. Every time the U.S. planes arrive, they can use those runways. Every time the forces arrive, they can use those barracks. And that makes sense both for the United States and for the Philippines. But the facilities are ours.
I see here language like unimpeded access to agreed locations on matters of prepositioning and storage.
Yes, Your Honor.
So there
that
is unimpeded access by the U.S.
That makes sense, Your Honor, because those materials are theirs. For example, materials for humanitarian assistance and disaster relief operations, that's theirs. Suppose they want, and we agree to preposition their weapons. That is theirs. And so it makes sense for them to have access because they have the technical expertise and know-how to maintain those materials. But they can be taken away because they are movables, Your Honor. They are movables.
But principally, these are for security purposes and not for humanitarian reasons.
Both, Your
That is
Honor.
only incidental. But you're invoking the MDT and the Visiting Forces Agreement. These
Yes,
are
Your Honor,
security arrangements.
We recognize
So
today.
the unimpeded access may have to do something to do with the security.
Yes, Your Honor. We recognize today that national security involves the ability to respond to disasters because if in the aftermath of every disaster, we are vulnerable. We are vulnerable. And so if you look at the practice of the United States insofar as visiting forces are concerned, those activities always have a component, and that component is military and humanitarian assistance and disaster relief.
Since the material and other supplies to be stored there will be principally for security purposes, will they allow civilian component to take care of this material, or will there be military personnel who will take charge of looking after this prepositioned material and
That-
for their storage?
On the EDCA, Your Honor, that depends. It can be the United States forces themselves or their contractors who will maintain this prepositioned defense and HADR materials and supplies.
But the contractors are commercial establishments whose work will only be concerned with the construction of the facilities and perhaps maintenance. But with respect to storage and prepositioning, do you think the U.S. will allow non-military personnel to do that for?
I'm sorry, Your Honor, I'm not familiar with the practice of the U.S. military insofar as maintenance of preposition material are concerned.
So prepositioning and storage may eventually require the presence of military component in the agreed location for extended period of time to be able to, these are sensitive equipment, and the U.S. may not allow civilian component or a commercial company to take care of this equipment.
That would be their judgment call, Your Honor, because those materials are theirs, not ours.
Now, what about this provision that any dispute will not be filed, will not be under the jurisdiction of Philippine courts, but will be subject to diplomatic discussions between the two countries?
Yes, Your Honor. That makes a lot of sense because this is a government-to-government agreement. In fact, it would be a bit strange if a government would totally submit to the jurisdiction of another government insofar as disputes involving military materials or activities are concerned.
But the
And-
language is very broad. Any dispute arising under this agreement, it does not say any dispute between the two countries.
It
It
says,
says any dispute. So what about labor dispute? What about a dispute between a U.S. contractor and a Filipino supplier? How, considering the very broad language of this provision, it may be difficult to just limit this to a dispute between the two governments. It doesn't between the U.S. and the Philippines.
it does, Your Honor. It says the parties agree to resolve any dispute arising under this agreement exclusively through consultation between the parties. The parties here, Your Honor, are the Republic of the Philippines and the United States. And so only disputes between the parties will be subjected to Article 11 mechanism. All other disputes can be subjected to the regular court system.
But that's not the import of the language of that provision. the consultations between the two countries does not limit the type of dispute. It's consultation is a remedy.
Yes, Your
That
Honor.
is a remedy. It does not describe the parties to the dispute. So this provision is very broad to cover any dispute. It may be a labor dispute. It may be a dispute between an employee,
No,
a
Your
civilian
Honor.
employee of the.
Again,
You-
Your Honor, these are disputes between the government of the Republic of the Philippines and the United States.
You may be
That
hard.
is
You may be hard put to circumscribe this provision, considering the language of the provision. But I don't know. how
Our
you can-
position, Your Honor, is that these are disputes that are government to government.
Now, the choice of the agreed location is to be agreed between the U.S. and the Secretary of National Defense.
And the government, Your Honor.
By what authority does the Secretary of National Defense be able to do that? To
As-
agree to these agreed locations under his own authority? Are there guidelines under EDCA?
Your Honor, he'll be acting as alter ego of the Commander-in-Chief. I suppose also it's his office that will have the institutional competence to make the proper calculations as to what the agreed location should be insofar as our interests are concerned.
Go back to the language of the transitory provision of the Constitution. It refers to foreign military bases, troops, or facilities. The section uses the conjunctive word or.
Yes, Your Honor.
So even if there's no military bases there, under the EDCA troops, there will be troops and there will be facilities under the EDCA of belonging to a foreign government,
Yes.
which will be present in the country.
Yes, Your Honor.
Now, the way the court interpreted this provision is that this will apply if there is permanent presence. So we were able to uphold the constitutionality of the BFA without the need of complying with this provision, because we consider the presence of U.S. military troops here as temporary in nature.
Yes, Your
So that would not come within the contemplation of this provision. Now, considering the difference, there are a number of distinctions between the BFA and the EDCA, and we find the words in the EDCA which will imply permanency. You ought to convince the court that
Yes,
this will
Your
not
Honor.
come under this provision of the Constitution.
Yes.
And even if we agreed that before that there need not be a treaty on the part of the U.S., it was under our understanding that Section 25 does not apply because
Yes.
it pertains only to temporary presence. So if the arrangement will come within Section 25 of the transitory provision of the Constitution, then a treaty on the part of the U.S. may be required, even if, insofar as the U.S. is concerned, it is a binding international agreement. Before, what they did is to send us a communication saying that this is a treaty in a general sense, insofar as they are concerned, but not in the strict sense, because it was not signed by, it was not
By the Senate.
submitted to the U.S. Senate. So these are issues that the court may have
Yes,
to
Your
resolve.
Honor, if I may, our answer is in fact rather straightforward. Article 18, Section 25 of the Constitution applies only to foreign military bases, foreign troops, and foreign military facilities. Insofar as foreign troops and facilities are concerned, the license has already been previously secured under the VFA. That's done. Insofar as the question of bases are concerned, we see no problem because these are Philippine military bases. And by the test of control, use, ownership, all tests imaginable, Your Honor, these are Philippine military bases. And therefore, the Senate's concurrence is not allowed. Insofar as facilities are concerned, if they are Philippine military facilities, we also don't see any problem. And so it's a rather straightforward position, Your Honor. And that's why we say that all licenses required by the President to enter into this agreement have already been previously secured. And therefore, there's no need to go to the Senate anymore.
Even under the MBA, the entire area of the U.S. facilities belong to the Philippines. That was the provision of the 1947 MBA. We own the. That was a concession that we were able to get under the 1947 MBA. So it's the same here. We also own, but the facilities under the MBA of 1947 are owned by the U.S. In the same way, the facilities now will be owned by the U.S. In fact, there is a provision that the turnover to the Philippine government will still be subject to agreement between the two parties.
There is a big difference, Your Honor. A basing agreement, Your Honor, is an agreement where the United States will have the general purpose license, a plenary activity to do whatever it is that they want to do within the bases. And so even if at some point those bases became ours by title, the United States in those bases had the power to do whatever it is that they want. And I read to you, Your Honor, the breadth of what the United States can do or could have done under the basing agreement. That is not present here, Your Honor. These bases are ours. We don't have just control over the perimeter. We have access to the entire agreed location. The facilities that will be built are ours. The permanent structures are ours. Operational control is limited to construction activities, but once those construction activities are over, it will be subjected to joint use, like those barracks, like those ports, like those runways. And so, Your Honor, we're not making a general statement about control or ownership. We are offering clear standards for determining whether or not these are Philippine military bases or foreign military bases. And what we're saying, Your Honor, by the standard of the Military Bases Agreement of 1947, they had control. That is why you can call them foreign military bases, even if we own them. Cannot. No one can say that these are foreign military bases because we own them, we have access, they're subjected to joint use.
But the Constitution does not speak of military bases only. It refers to troops. It refers to facilities. So, and our understanding is that if the presence of the troops or the facilities owned by a foreign government when it is permanent in character, then that will come under the contemplation of this section of the Constitution.
That is true. That is true, Your Honor.
It's not required that there be a military base.
Except that, Your Honor, the trooping agreement, the treaty with respect to the presence of troops and the facilities that they carry so that they can become a force, has already been previously secured through the VFA. The VFA was a treaty that was ratified by the Philippine Senate. And so the policy is already there. In 1999, the Senate said, we are open to allowing United States forces to have presence here in the Philippines. And so what we're saying, Your Honor, is that the EDCA derives entirely from the VFA insofar as the presence of those forces are concerned. And that is why there's no need for another round before the Senate.
The language of EDCA already grant to the U.S. certain authority under the EDCA within the agreed location. So this will no longer be subject to discussions because
no,
the
no, Your
language
Honor.
is grant, already grant.
The language gives the range of activities that may be permitted. That is the understanding of the Philippine panel, and that's splattered all over the agreement, Your Honor. There must be prior approval. It must be upon the invitation. And so this is not a license to do everything that is enumerated there. It's a license to do what is enumerated there if the MDB and the SEB approves it. That is the EDCA, Your Honor.
Already under this, well, you just explained that in your memorandum, but
Yes, yes,
from my
we will.
reading, the authority of the U.S. is already granted pursuant to a bilateral security mechanism in the MDB and the SEB.
Yes, those
so
are
it's not
consent-
something that is still conditional or to be agreed upon. It's already granted. The
It
Philippines
is-
hereby grants to the U.S. through bilateral security mechanisms.
Yes.
So there is already a grant.
Your Honor, those bilateral mechanisms are the consent mechanisms. Those are the Philippine institutions that must agree to what the United States can do, to the range of what the United States can do within the agreed locations.
You can,
Every activity, Your Honor, must be pre-approved by the MDB and the SEB. No prior approval, no activity. And so you can imagine, Your Honor, a rather large base. The United says, the US says, we want to construct a runway. The Philippines says, we don't think you have to construct a runway. It cannot be done. The United States, we think we want to construct some barracks there. Okay, we agree with that. That's the MDB and the SEB. They want to preposition defense material or HADR materials. We have to agree. And so for every activity, Your Honor, we have to agree. That is consistent with the language of the EDCA. That is the core mechanism of the VFA.
the EDCA mentions consultations many times.
Yes,
no?
Your Honor.
So it's always by consultation. You know, do you think we have enough bargaining power to be able to impose what we want?
My understanding, Your Honor, is that the EDCA is a convergence of interests. Independent of the desire for altruism, I think the United States has certain security interests in the region, which is why they want to partner with the United States, with the Philippines. They want to improve our facilities so that we can develop minimum credible defense. Regardless of the interests of the United States, we have our own interests, Your Honor, in protecting our territory, in improving our bases, our facilities, in having our troops trained properly by another force. And so what we have here, Your Honor, is a convergence of interest. No one denies the United States forces are more technically equipped, have greater resources. But given our independent interest and their separate interest in coming over here and assisting us, I think, Your Honor, that might be a good platform for a bargaining position.
Earlier, you mentioned that we cannot force the Senate to assume a responsibility that it did not seek. Are you warning us that there may be a constitutional crisis if the court decides to rule that a need for Senate concurrence to this treaty? Is that your position?
Well, not necessarily a constitutional crisis, Your Honor. What we're saying simply is that the special role of the court to arbitrate constitutional questions assumes the existence of something to arbitrate. That the court must allocate constitutional boundaries only if there are real institutions that are fighting. Here, the President has characterized a particular agreement as an executive agreement. The Senate is not complaining. If there's an institution whose prerogatives have been diminished, it has to be the Senate. Everyone who disagrees, Your Honor, with the EDCA are political oppositionists, and that is respectable as a matter of free speech. I can disagree with the EDCA and still agree with the power of the President to characterize this as an executive agreement. But what we're saying, Your Honor, is that the court's power must be used properly. And here, you don't have that occasion, Your Honor, to exercise that power to allocate constitutional boundaries, because we need to understand that in politics, silence can be very meaningful. And the silence of the Senate on a matter that potentially involves their prerogatives should be very telling to the Honorable Court.
You give too much importance to the silence of the Senate, but this case was filed with this court early enough. And it could be that the Senate is deferring to the decision that the court may take in this case. So, I don't think it's fair for us to make any conclusion from the inaction of the Senate.
There is an objective fact from which we can base our conclusion, Your Honor. It is that none of the petitioners here is a senator, is a current member of the Senate. You don't have a resolution before us, Your Honor, authorizing the members of the Senate to file a case before the Supreme Court because the senator's institutional prerogatives have been diminished or impaired by the President. That is a fact, Your Honor. And I suppose it's logical to assume that if an institution doesn't complain about what is purportedly a very important prerogative on their part, that they are not complaining. And if the Senate actually agrees that the EDCA is an executive agreement, then that is it. You know, a referral would actually potentially embarrass the court, because if the court forces the President and the President obliges, and the Senate simply says, oh, you know what, we didn't file a case because we actually agree this is an executive agreement. Where does that put the court? It puts the court in a rather awkward position where two institutions have converging interpretations against the interpretation of the court. And so our position, Your Honor, is that we should not unnecessarily pit institutions against each other. We have to wait for a real fight. And there's no fight here, Your Honor, because the Senate is not complaining. And the only conclusion, a reasonable conclusion we can gather from that silence is that the Senate agrees with its Commander-in-Chief.
It's for the court to decide whether it will exercise its constitutional duty.
Of course, Your
in
Honor,
deciding
of course,
this case.
of course.
Just a few observations from what you have stated during the interpellation of
Yes, Your Honor.
Justice De Castro. You said and you agreed that under the arrangement in EDCA, there is going to be a joint military base. The Philippines owns it, and the Americans builds the facilities, etc., on the territory owned by the Philippines. And at any time that the U.S. would want to come here for a military exercise, they have the operational control over this bases. You agree that it is a joint military base. If it is a joint military base, is it not that it is both a Filipino base or a Philippine military base and an American military base? And as far as that aspect is concerned, it being an American military base, that is prescribed in the Constitution if it is not made through a treaty.
Your Honor, this is not a joint military base. There will be joint use of certain structures within the Philippine military base. The bases are ours. Again, Your Honor, if I give the example, they construct the barracks. We can construct the barracks on our own.
So the Philippines can refuse when the Americans come over and say,
can we use this military base on which we have constructed so many things, airports, etc.? The Philippines can say, no, you cannot use this. This is ours. Is that what the EDCA means?
If the Philippines does that, Your Honor, then the Americans can complain and there will be a resolution of disputes under Article 11 of the EDCA.
And therefore, it is not absolutely Philippine military base. It is, conceding your point, potentially, if not actually, an American military base whenever the American forces come in. Okay.
Your Honor, an owner doesn't have to secure permission. The
Right.
United States will have to secure our
Correct.
permission. That is why...
And the Americans, when the Americans secures permission, the Philippines can say, no, I won't give my permission.
That is the nature of our permission, Your Honor. You can say no.
And that is provided for in the EDCA.
Every activity will have to be pre-approved, consistent with the core mechanism of the VFA.
The next question is, you are saying that in so military forces and the facilities are concerned, there has already been a license for that, which means this is in reference to the declaration of constitutionality by the Supreme Court of the BFI agreement because it was through a treaty.
Yes.
If the court, in its considered opinion, says that there is a very big difference between the provisions in the EDCA and the BFA, cannot the Supreme Court conclude that, therefore, this agreement, whether it is termed international or executive agreement or a treaty, should be referred to the Senate for its concurrence?
What we're saying, Your Honor, and I spent a lot of time on that earlier, Your Honor, that it cannot be done. The choices for the court are only either to dismiss for substantive or procedural grounds or to grant the petitions.
You went into procedural and substantive grounds. What is the issue before the court? Is it the merits or the constitutionality of the provisions of the EDCA or the constitutionality of the process by which it was entered into?
For us, Your Honor, the preliminary issue is the standing of the parties. And that's
Don't beat
That's-
around the bush, Mr. Solicitor General. I am asking what is the issue before us. The constitutionality of the provisions of the EDCA or the process by which it was entered into.
well, I suppose, Your Honor, if you don't want to go into the jurisdictional concerns, the only issue is substantive. There's no procedural concern because the procedural concern rests on a substantive reading, whether or not these are foreign military bases.
And then I go back to my original position that if and when the court says that this EDCA is vastly different or it's a different animal from BFA, then the provisions, the procedure in Section 25 must be followed. And I will have to recall what I stated during the first oral arguments, that the provisions of 25 is not merely procedural, but in a sense, or it is the very essence. It is the very constitutional requirement before visiting, before troops, bases, and facilities can be made here in the Philippines. And the process needs Senate concurrence, without which there cannot be any foreign troops or facilities or bases here in the Philippines. And I even posited the opinion that if and when the process of 25 is completed such that the Filipino people has been consulted by the Senate through a Senate decision, and all the provisions of the let's say another EDCA is ratified, then it is beyond this court to question the provisions of such an EDCA. Because the Filipino people has spoken, assuming it has done so, and this court question the provisions, which is why I see or I understand why there is such difficulty in the discussions, because we are discussing the merits or we are discussing the provisions of the EDCA.
Your
Assuming,
Honor.
of course, that it is already licensed by the previous decisions of the court.
Your Honor, our position is that the Filipino people have spoken. They have elected. That Commander-in-Chief has already acted pursuant to his Commander-in-Chief powers, which is what? To allow visiting forces pursuant to the Visiting Forces Agreement and to allow the United States and their contractors to improve our bases and proposition material.
On the premise that the EDCA is a mere expansion of the BFA. But as I said, if the court finds that this EDCA is a different animal, then we will have to declare it unconstitutional.
The EDCA, Your Honor, incorporates the licenses from the VFA and the MDT. That is our position. Of course,
Thank you, Mr. Solicitor. We're going around
Thank
in
you, thank
circles.
you.
I'm finished.
Justice Velasco.
Mr. Solicitor General, there is the insistence on the part of the petitioners that the EDCA is actually a military basis agreement, right?
that is their insistence. Your
Can
Honor.
you explain to us the difference between the military basis agreement and the EDCA, which is now being assailed in these petitions?
As I mentioned earlier, Your Honor, we offer several standards for determining whether or not these are foreign military bases. Use, ownership, extraterritoriality, and most importantly, control. Under the Military Basis Agreement of 1947, it's very clear.
Excuse me, Mr. Solicitor. Can you just cite the specific provisions in the military basis agreement and compare it with the pertinent provisions in the EDCA so that we can be easily guided?
Allow me to refer you, Your Honor, to Article 3, Paragraph 1 of the 1947 Military Basis Agreement. Article 3, Description of Rights. Number 1, it is mutually agreed that the United States shall have the rights, power, authority within the bases which are necessary for the establishment, use, operation, and defense thereof, or appropriate for the control thereof, and all the rights, power, and authority within the limits of territorial waters and airspace adjacent to or in the vicinity of the bases, which are necessary to provide access to them or appropriate for their control. This is plenary power, Your Honor. This is the general purpose license that we are referring to. What we're saying, Your Honor, is that if you give this to a foreign military force, it becomes a foreign military base because they have full control.
What is the parallel provision in the EDCA pertaining to
Nothing,
the
Your
power
Honor.
of the U.S. government over
Nothing.
the agreed locations?
The power of the U.S. government in the agreed location is the power to request. The power to request license for specific activities. They want to construct, we have to agree. They want to proposition, we have to agree. All the requests that they have will have to go through consent mechanisms.
Okay, Article 6 on security, paragraph 3 or item 3, states that U.S. States forces are authorized to exercise all rights and authorities within agreed locations that are necessary for their operational control or defense, including taking appropriate measures to protect U.S. forces and U.S. states contractors. The U.S. should coordinate such measures with appropriate authorities of the Philippines. Does this not mean that the U.S. forces have absolute control, considering they are given the authority to exercise all the rights and authorities within the agreed locations?
No,
and
Your
the
Honor.
only thing that they are needed to do is just coordinate?
No, Your
This is
Honor.
a very clear provision in the EDCA. So you're saying that the U.S. will still have to get the approval of the Philippine government before they can exercise such rights and authorities within the agreed locations? Are you
allow
saying
me-
that this provision is vague?
It's very clear, in fact, Your Honor, and I will explain to you, if I may, the meaning of operational control. Transferable command authority that may be exercised by commanders at any echelon or below the level of combatant level. Operational control, Your Honor, is not with respect to an area. Operational control is with respect to subordinates. And so, if we say they have operational control and the right to defend themselves, that makes a lot of sense because, number one, it's their forces. A superior commander has the right to command and control all subordinate officers and members. Do they have the right to defend themselves? Of course. Is it reasonable to give them operational control over their own forces? Yes. Is it reasonable to give them the power to defend themselves in case of an attack? Well, of course. But they are within Philippine military bases and Philippine military facilities. They don't have control over the bases. We have control over our own bases. But it makes sense for the military commanders of the United States to have control over their subordinate officers and employees.
Okay, where did you get that kind of meaning of the phrase operational control? During the negotiations for this EDCA, were the negotiations placed in the black and white or recorded so that the parties can refer to that in case there is a disagreement as to the meaning of the phrase operational control or defense?
Your Honor, this is the 2014 Philippine Air Force Operations Manual, Operational Control. My
There's a
understanding is
definition
that
there?
the
There's a
United States
definition?
has basically the same definition. In fact, Your Honor, when we were preparing for the oral arguments, I asked the negotiators, what does this mean? Philippines hereby grants the U.S. through bilateral security mechanisms such as MDB and SCB operational control of agreed locations for construction activities. Can I say during the oral arguments, agreed operational control of agreed locations only for construction activities? Their answer was yes. That is what the agreement says, and that is what they intended.
Okay, but we're talking about item 3 of Article 6 on security, and you referred to paragraph 4 of Article 3 on construction. But the U.S. forces in the agreed locations can undertake any activity under the pretext of exercising operational control. Is that right?
No, Your Honor. Their operational control is the power to control the subordinates.
How about the operations
And that
of
is
the
important for
subordinates?
discipline, Your
How
Honor.
about the activities of the
The
subordinates?
activities of the subordinates will have to be pre-approved by the Philippine government through the MDB and the SEB.
All these
We have
activities?
to distinguish, Your Honor, the power of control of the military commander over the subordinate military officers. That makes sense because the military is a hierarchy, and they have to defend themselves in case they are attacked. And operational control is a technical term. When you say operational control, it's not control over anything and everything. Under the manual of the Philippine Air Force, Your Honor, it's transferable command authority that may be exercised by commanders at any echelon at or below the level of the combatant level, or below the level of combatant command. And so control refers to human beings, Your Honor, not to areas.
Are you sure of that?
Yes, Your
Because-
Honor. I clarified this several times with the negotiators.
Okay. You mentioned MDB and SEB, okay? Bilateral security mechanisms. But Article 3, Paragraph 4 mentions that or cites that in relation to construction activities, right?
Yes, Your Honor.
There is no mention at all of the bilateral security agreements pertaining to Article 6 on security. They did not explicitly subject of bilateral security agreements, correct?
Yes, Your Honor, because it makes sense for a superior commander to have control over inferior officers. I suppose, Your Honor, that is inherent in a military command, that you have a chain of authority, a hierarchy, and that hierarchy starts with the superior having operational control over the subordinates.
Considering the absence of such bilateral security agreement, then it will be very difficult for the DND or the BFA to know and monitor these activities pertaining to the operational control over the U.S. forces, correct?
No, Your Honor. If I may give an example, just to clarify.
Not an example, just tell us what the Philippine government can do with respect to the activities
They can
undertaken pursuant to the
Yes.
operational control over the agreed locations. We want to be clarified.
Yes, Your Honor.
Yes.
What the Philippines can do is to condition the permission in the activities, right, that the U.S. forces can do. And the U.S. forces, because they have a command chain, will have to follow, will have to have operational control over their own people. But what can be done in terms of the activities that they can do, like for example, training in humanitarian assistance. Right? What they will do is train Filipino military officers and military personnel in humanitarian assistance. In that training, it is natural for the United States forces to have control over their own forces. Because it's not as if the Philippines should have control over every American soldier that visits here. It's understandable, Your Honor, for the American forces that come over here, for their commanders to have control over their inferior officers and soldiers. But our control is at the level of the permission for the activity that they can do. If we say, for example, you can train for humanitarian assistance, they cannot train for espionage, or they cannot use their military for surveillance. Why? Because the permission that was granted by the Philippine government was humanitarian assistance or disaster relief. So that is the level of control that we have.
You make mention of permission, but item 3 of Article 6 does not mention any permission from the Philippine government. It only mentions coordination. And what does coordination mean, Mr. Solicitor General?
Coordination, Your Honor, is when the United States decide to defend themselves. When they decide to defend themselves, they will defend themselves if attacked.
Precisely.
And that fact will have to be coordinated with Philippine forces. But that has nothing to do, Your Honor, with the activities that are approved by the Philippine government. If I can give another example. Suppose they are licensed to perform a particular activity, like maritime domain awareness. It will be unusual for them, Your Honor, not to react. It is their right to defend themselves. And when they defend themselves, they will do it at the instance that they are attacked. Once they are attacked, they will say to the Philippine government, We were attacked, we are coordinating the matter to you, so maybe in the future we can prevent attacks. That is the coordination mechanism. But if you're looking at the permission for the right to defend, that is inherent, Your Honor. That is inherent in the American forces, because they are forces and they need to defend themselves when they are attacked.
Okay, so that's really the difficulty with this arrangement, because the term, it can react right away to certain situations without first getting the permission of the Philippine government, correct?
Allow me to give another example. If
Yes,
the Philippine
but
forces
in
were
the example
sent...
you gave, in case of an attack on them, definitely they have to act right away and defend themselves. And they need not go to the Philippine government and say, "Hey, can we get your permission to
Yes.
defend ourselves?" Of course not, that's
If-
what you're saying. But what that this brings to the fore is that they practically have full control over the agreed locations in terms of security. And that this is what is most important.
Again,
the
Your
right
Honor,
to use a military force and weapons to protect themselves, right?
if I may, if Philippine
Yes.
forces are sent to, say, Indonesia or India, and those Philippine forces are attacked, those Philippine forces will have to defend themselves. Same thing here, Your Honor. It would be totally unnatural for a person who is a soldier, a military person with all the weapons and equipment, not to respond in case of an attack. That is a natural reaction of a person who is under attack, to respond by defending himself or herself. About military operational control, if the United States forces are sent to, say, some shoal or some reef for purposes of maritime domain awareness or maritime security, would it make sense for the United States forces to have operational control over their own soldiers? It makes sense, Your Honor, because that is the way to ensure discipline. That there's a person to which these foreign soldiers are responsive to. There's a person that these foreign soldiers will follow. And that makes a lot of sense. But the nature of the activity will be dependent on the Philippines. Will be dependent on the Philippines. What is our permission? If our permission is for humanitarian assistance, they can't do maritime surveillance. If our permission is for maritime surveillance, they can't go to any calamity that they find and assist. That is the meaning of control on the part of the Philippines. But operational control is control over the soldiers. And the right to defend is a natural, is a reasonable right of any human being, Your Honor.
In the MBA, the commander of the U.S. forces also have operational control over the forces in the bases, right?
Just like-
So, they have the same powers in the two arrangements, in the MBA and the EDCA. They have the same powers, right?
Yes, of course, Your Honor. But what I'm trying to clarify is the difference between control over locations and control over persons. A colonel will have control over everyone under his command. And that makes a lot of sense. But that colonel having operational control over his soldiers will not have control over Philippine bases. Because those bases are ours, we have access, we can condition the permission with respect to every activity that they can do. They won't come into our bases and do whatever it is they want to do. That is what they could have done under the military basis of Agreement of 1947. When they enter their bases, they can do whatever it is that they can do. They cannot do it under the EDCA. When they come here for a specific purpose. Will they have operational control? Well, yes, of course, because that's their forces. Do they have the right to defend themselves? Yes, of course, like Philippine forces in another soil, in foreign soil. That seems reasonable to me, Your Honor.
What are the other provisions in the EDCA that you consider to be different from the MBA? other than the operational control matter?
Well, our answers, Your Honor, are simply responses to the arguments of the petitioners.
That one.
The claim is that these are foreign military bases. Our answer is we're giving you a test, several tests, in fact, to determine whether or not these are foreign military bases. By those tests, by those standards, no one can consider these foreign military bases.
In the MBA, they are allowed, of course, to construct buildings and structures. And the same thing is given to the
There's
US
a big
forces
difference.
in the EDCA, under
There's
the
a-
EDCA, correct?
There's a big difference, Your Honor. Within the U.S. bases, under the MBA, they can construct whatever it is that they want. If they say, we need facilities for maritime domain awareness, can we do that? Yes. Do they need to secure permission from the Philippine government? No. We need to secure, we need to have facilities for humanitarian assistance. Can we do that? Yes. Do we need to secure permission of the Philippine government? No. Here, Your Honor, you have an entirely different permission system. You have an entirely different regime. This is a different model. This is a different paradigm. They come here with a purpose. They come here not because they want to have fun. They come
For the US forces to construct certain structures, they need the permission of the Philippine government. Is
Yes.
that correct?
Yes, Your Honor.
What's your basis for saying that? Because under paragraph 4 of Article 3, it explicitly states that the Philippines has already given its permission to the United States operational control of the agreed locations for construction
construction.
activities and authority to undertake such activities on or make alterations and improvements to agreed locations.
Allow me to
There's
read.
already a blanket authority and consent given
Quite
to
the contrary.
to the U.S. government, to the
quite-
U.S. forces.
Again, Your Honor, quite the contrary. Article 3, paragraph 4 says, and I will read to you the specific language, Your Honor. The Philippines hereby grants to the United States through bilateral security mechanisms such as the MDB and the SEB, operational control of agreed locations for construction activities. Every time, Your Honor, we have the MDB and the SEB, we are invoking the power of the Philippine government to agree and to approve. These are consent mechanisms, Your Honor. Without the consent of the MDB and the SEB, they cannot do anything.
So can you cite the specific provision in the MDB and SEB that says prior consent is needed before construction can be undertaken by the U.S. forces? Can you cite the
Well,
specific
Your Honor,
provisions?
the most important function of the MDB
No,
and
no,
is
no.
the
I
SEB.
want you to cite the specific provision that clearly states that the consent and approval of the Philippine government will still have to be procured or obtained before construction is done by the U.S. forces. Can you cite that?
The preamble, Your Honor.
It's in the preamble, but is there any specific stipulation that says that?
It's as
Clearly
specific
and
as
explicitly?
that, Your Honor. It's as specific as that. And if I may read to you the preamble, recognizing that all United States access to and use of facilities and areas will be at the invitation of the Philippines and with full respect for the Philippine Constitution and Philippine laws.
I want
They,
you to
they
cite-
can't
excuse
construct
me,
if they're not
Pal-
given access in the first place, Your
Correct,
Honor.
correct. Excuse me, but you may have mentioned MDB and SEB, and I want you to, you're saying there's an explicit provision there, but you refer to the preamble of the EDCA, and it's just a general statement that the U.S. government will respect the Philippine Constitution and laws.
No,
But
no,
you're
Your
saying-
Honor.
Yes, you cite the specific provision in the MDB and the SEB.
What we're saying, Your Honor, is that the preamble contains the all-important operation of the entire EDCA. And what we're saying here, Your Honor, is that consistent with the VFA, all activities will have to be pre-approved.
This is a general statement. Usually, this is integrated or incorporated in agreements because definitely the foreign government will have to respect our Philippine laws and constitution. But more importantly, we're talking about details in the implementation. And if there is no clear reference to any specific provision in the MDB or SEB, then this will be subject of numerous discussions between the contracting parties. Are you saying that this agreement is not clear and complete?
Your Honor, the negotiators, I suppose, could have included in every paragraph and every line of the entire agreement that you have to have the NDB and the SEB. But they have chosen another path. And the question, Your Honor, is that is that path a reasonable path? That path is this. They have included in the preamble this general provision. All U.S. access to and use of facilities and areas will be at the invitation of the Philippines. It cannot be any clearer than that, Your Honor. We could have drafted the EDCA differently, but there's no way anyone could have foreseen all the questions of the justices. And so the only question, Your Honor, is that, are the submissions of the government consistent with the text of the EDCA, and are those submissions reasonable interpretations of what the negotiators have done? And what we're saying, Your Honor, is that you have to be entirely cynical and sarcastic to disagree that what we're saying here is wrong.
Mr. Acting Solicitor General, I'm sure you have crafted a contract or an agreement before,
Yes.
right?
Yes.
And don't you think that an agreement should be clear, without equivocation, and complete in all the aspects pertaining to the agreement? Don't you think that should be?
I personally believe, Your Honor, that this agreement is rather clear.
It is clear.
It's very
okay.
clear, in fact.
All right. I direct you to letter B, para arrangement will be implemented.
Again, Your Honor, when we say as mutually determined by the parties, what it means is that if the MDB and the SEB agrees, this is again, Your Honor, an example of the consent mechanism that we are referring to. So when we say authorizing actions on a rotational basis as mutually determined by the parties, what it means is not that the parties have already mutually determined that access will be granted on a rotational basis. What it means is that access will be granted on a rotational basis if the parties mutually agree. And this is consistent with the preamble. This is consistent with everything that you read in the EDCA.
So, in short, there is still no agreement as to the rotational arrangement for
The
access
EDCA
to the agreed locations, correct?
Correct, Your Honor. The EDCA, Your Honor, is a framework agreement for agreeing to specific activities, whatever those activities may be.
In the MBA, what is the period of effectivity of the MBA? That already lapsed, right? But what was
Originally, Your Honor, it
stipulation
was, I
there?
think, 99 years, reduced to 25 years, and then, of course,
What is the period or the term of the EDCA agreement, the EDCA?
the EDCA, Your Honor, has an initial term of 10 years.
10 years. And then what does the remainder of the provision state?
It says, and thereafter it shall continue in force automatically unless terminated by either party by giving 1 year's written notice through diplomatic channels of its intention to terminate this agreement.
So in short, in reality, there is no fixed term unless one party terminates it, correct? It goes on and on. There's an automatic renewal.
Your Honor,
Which is better between the two? The fixed term in the MBA and this stipulation here?
semantically, Your Honor, it's equivalent.
It is
It is equivalent.
to your mind, huh?
Objectively, Your Honor, it is equivalent. Why? Because I don't think anyone will forget the end of the term of the EDCA, especially the petitioners. No one will forget that 10 years will lapse, Your Honor. And before those 10 years are through, someone, the DFA, the DND, will consider whether or not they still want to continue with the EDCA. If they don't want to continue with the EDCA, what do they do? They will file a notice of termination. If
Correct.
they want to continue, all that they have to do is nothing.
Okay, so if you have an administration who is very generous and accommodating, this EDCA will be automatically renewed because that administration will not terminate the agreement, correct? So it's open-ended in the sense that there is an automatic renewal clause. Okay?
Your Honor, what is crucial in terms of contract, Your Honor, is not the automatic renewal. What is crucial is the ability to terminate. It is indefinite if we didn't have the power to terminate. And so if I'm trying to enter into a contract with you and I want to make it appear as if this is an indefinite agreement, I can couch the language differently. But to lawyers who understand English, this means this is good for 10 years. If you don't say anything, this is automatically extended. But if you
Precisely.
complain, you can terminate it. And so whether or not it's an automatic renewal or initial term, 10 years subject to renewal by the parties, it's semantically and objectively the same.
Okay, with regard to purpose and scope, more particularly scope of activities, item 3 of Article 3 states that the parties agree that the U.S. may undertake the following types of activities in the Philippine territory in relation to access to and use of the agreed locations. And the last part of the stipulation states, and such other activities as may be agreed upon by the parties. So this is open-ended again. The parties may agree later on as to other kinds of activities other than those enumerated or listed in that particular paragraph, correct?
That is correct, Your Honor, and that is consistent with the decision of this Honorable Court in Lim versus Executive Secretary. In Lim versus Executive Secretary, the court held activities was left ambiguous. Why? Because the intention was to give the parties certain leeway in negotiation. That is the decision of the Honorable Court, Your Honor.
But this is a very important alleged executive agreement, and this is a question in the sense that this may open up the use of the agreed locations to such other activities other than those explicitly stated in the EDCA, correct?
They can do that, Your Honor, even without the EDCA. Because we already have the VFA, we have the authority under both the VFA and the decision in Lim versus Executive Secretary to constrict or expand, the activities that are allowable. That is possible, Your Honor, even without the EDCA. That decision has already been made by the Supreme Court in Lim versus Executive Secretary. And so, insofar as that question is concerned, Your Honor, it's the decision of the court that is the strongest argument.
Okay, how about implementation? Paragraph 2 of Article 10 also says the parties may enter into implementing arrangements to carry out the provisions of EDCA. So, in short, we are open to such other implementing agreements which are not explicitly stated here.
I suppose, Your Honor, nothing but activities, prepositioning. Again, this is a framework agreement. The parties can go down to the level of greater details in implementing this framework agreement. But it still has to be consistent with the EDCA because it's a framework agreement.
So it's your position that based on the stipulations in the MBA and the EDCA, that this arrangement cannot be considered as an agreement on permanent military bases. That's your position, right?
This agreement, Your Honor, is an agreement on permanent Philippine military bases.
This is
Philippine military bases, Your Honor.
Philippine and not U.S.
Yes, Your Honor.
Although, yeah.
The only agreement for which you need Senate concurrence is an agreement with respect to foreign military bases. These are Philippine military bases, Your Honor. We can do whatever it is we want with our Philippine bases.
Okay, so you're saying that this agreement pertains, that the agreed locations pertain to Philippine military bases.
By ownership, use, jurisdiction, and control.
And so you're saying that these agreed locations will only pertain to Philippine military bases now existing or to be established in the future?
Under the EDCA, Your Honor, the agreed locations are given by the Philippine government through the AFP. And so they are military areas.
Okay, and that's all, Mr. Solicitor. Thank you.
Justice
Thank you,
Bersamin.
Justice Velasco.
Thank you, Chief. Good evening, Mr. Solicitor General.
Good evening,
The
Justice
first
Bersamin.
question that I would like to ask of you is this. Are you here for all the marbles? Meaning you will not permit a situation where we declare partially an unconstitutionality? Or you want the whole to be declared constitutional?
Nothing prevents the court from doing what it wants.
That's why I had to ask that, because a treaty is like a law, and a law may be partly constitutional, partly unconstitutional. So if we did not want this agreed locations provision, we may strike it out as unconstitutional. Are you going to concede that?
Well, of course, that is within the power of the court, but there's a difference. When the Supreme Court declares an ordinary statute partially unconstitutional, then that partially unconstitutional portion simply has no effect. But when the court declares as partially unconstitutional a binding treaty, a treaty that's already entered into force, there are consequences for the Philippines as a state party.
Okay. Now, is it your contention that this EDCA is not a basing agreement?
It's not a basing agreement, Your
It's
Honor.
not a basing agreement. Even if certain provisions of it refer to agreed locations where you may construct airports, bunkering of vessels, and other facilities that are basically military bases.
Bunkering, Your
character.
Honor, is just refueling. Bunkering is just refueling of vessels, Your Honor.
Yes, but if you have refueling facilities, don't you have permanent facilities there?
Those are permanent facilities.
You
and
do
on the
not bring
assumption-
only trucks with fuel there to bunker a vessel
Yes.
that will require tons of fuel.
Those facilities, Your Honor, are Philippine facilities.
Philippine facilities.
Yes,
Now, the
sir.
question of Justice Velasco was this. Are these agreed locations referring only to existing ones or even to those not yet existing as of the time of the signing of this EDCA?
Nothing prevents the Philippines from acquiring other military areas for purposes of creating these agreed locations, Your Honor.
So right now, do you have any fixed idea of how many have been agreed locations in Luzon, how many have been agreed locations in Visayas, and how many in Mindanao?
My understanding, Your Honor, is that the Philippines and the United States have yet to formally agree
To
on
formally
the
agree.
number of these agreed locations and what these locations may be.
So these locations may be inland, maybe near the shore, maybe in the metropolitan areas or anywhere that the Philippines wants to allow these Americans to come in.
The limitation, Your Honor, is that they must be owned by the Philippine government through the AFP.
Well, I will assume
So-
that that is correct because the Philippines is for the Filipinos.
Yes, of course.
Now, will you permit Ambassador, who was the ambassador with you today? Malaya, to answer some questions?
Your Honor, I'm here as their counsel.
Yes, but if I do not like you at the moment, may I request you to permit Ambassador Malaya to take the floor?
Ambassador Malaya is requested to kindly stand.
This is the court.
Yes, of course, Your Honor.
Kindly approach the podium, Ambassador Malaya.
Ambassador Malaya is a lawyer, according to Professor Leonen, Dean Leonen. Di magaling sa
You may consult
Magaling
the Solicitor General before you answer, but you are being requested by the court to answer the questions to be propounded by Justice Bersamin.
Your Honor, the Philippine panel is represented by the Office of the Solicitor General. If there are factual items that I may know where I and the other panel members are ready to provide those information so that the Solicitor General can include it in the written memorandum which can be submitted to this honorable court.
Yes, you can withhold information if it is by any means covered by any secrecy or confidentiality, because I know you were a negotiator. I will respect that status. But there are facts that I don't think the solicitor can answer. Only the negotiator can answer. Now, if you do not like to answer, you can tell me. I am kind enough to forgive you for that.
Your Honor, these are very technical military matters, and
Well,
I come
technical,
from-
I can absorb.
Yeah, and I primarily.
Yes.
And with me in the panel are 5 other people, and it is chaired by the Undersecretary of the Department of National Defense. If there's anybody from us who can probably answer the questions of the Honorable Court, probably Undersecretary Pio Bettino can do it best for us. And also in reference to the particular question that you were asking on
No,
the,
I'm not yet asking you a
provision.
question. But I'm giving you that liberty to tell me off if you did not like to answer.
Your Honor, may I defer to my panel chair, Undersecretary Pio Bettino of the Department
Undersecretary?
of National Defense.
No, no, I like you. No, you know, a diplomat is more diplomatic. Okay, this is very simple, Ambassador. The timing of this agreement is very essential to my part of the case. I seem to recall that the visiting forces agreement predated the Abu Sayyaf incident where people were kidnapped from Dos Palmas, and then there were other incidents. The visiting forces agreement came into being in 1999. That is my recollection, and that is based on what I also read in the pleadings. Now, many years later comes this EDCA. Does this coincide with any incident? Like West Philippine Sea?
Well,
If you do not like to answer that, it's okay.
Well, diplomatic military initiatives like this, Your Honor, comes within a context. The geopolitical developments within the region, as well as the requirements of the Philippine military in the way that it can respond to exigencies. So, in his assessment, the President thought that it is timely and necessary that we enter into this type of relationship with the United States, a military cooperation agreement. That's why we entered into negotiations with the U.S. on this EDCA, Your Honor.
Okay, so this agreement was bound to happen. It was not accidental. It was bound to happen. You know, we have had history of unrest, security problems in the South. Was that the reason? Now, you can withhold information if you don't like to answer that. These things would be better. I think you would expect these questions if these were put to the Senate for ratification. But unfortunately, the stance of the government is not to submit this to the Senate. So it becomes inevitable for me, at least, to ask you this. But I will respect the state secrets that you would like to keep if you would call it that way. Are we clear about this?
Yes, Your Honor.
Now, that is a question that I ask you. If you do not like to answer, it's okay.
Well, this is not necessarily with respect to developments in the South, if you're referring to the extremist elements there, Your Honor, because that is in a sense an internal security challenge for the Philippines. This EDCA addresses the external defense requirements of our Philippine military. It is anchored on the Mutual Defense Treaty as well as the Visiting Forces Agreement. So this is a military to military cooperation agreement, Your Honor.
Okay. Now, I'm just wondering aloud why it would happen as late as in this term of this president that since this kind of framework agreement would be crafted or entered into when how many presidents have we had since 1999? No one of them thought about it. Was this out of a necessity that happened only recently?
Well, this is partly a response to developments which we are familiar with already, Your Honor, as well as
What developments?
the evolving political security developments that the Philippines faces. So, this is a response not just to one specific development, but to a totality of the evolving security challenges that the country is facing, Your Honor.
Like Yolanda?
Well, it has been, I think, sufficiently mentioned that the United States has been extremely helpful to us in humanitarian assistance and disaster relief, as shown during the Yolanda incident last year, and so many other instances, Your Honor.
Okay. The main claim of the government is that this is a framework agreement that seeks to implement the Visiting Forces Agreement. That is the stance of government.
That is right, Your
You
Honor.
confirm that. Now, if you read very carefully the Visiting Forces Agreement, I don't see any statements there regarding bunkering, training, transit, refueling of aircraft, and rotational troops. In the same way that this is now being used in this agreement, EDCA.
Your
So
Honor,
it's an expansion of the BFA, don't you agree?
may I defer to the Solicitor General for
Okay,
for
that's
the
a legal
response.
question. I will have the Solicitor General answer.
Thank you very much, Your
But
Honor.
please stay there. I like you.
Your Honor, this is my attempt to get liked more by you. Anyway, under the VFA, Your Honor, it already allows the entry of vessels and aircraft. And so it's necessary, of course, that these vessels and aircraft, in cases of emergency, be able to do and perform everything that is necessary for them to stay afloat, I suppose. The EDCA, consistent with the VFA, simply creates the details for the arrangement for bunkering, refueling of these vessels.
But the BFA is a BFA, Visiting Forces Agreement only. Nothing about agreed locations.
Your Honor, that is true, of course. What we're saying is that insofar as the Senate's concurrence is required for troops and their equipment, supplies, and materials, that's for the VFA. But insofar as agreed locations are concerned, that is what the President can and do as Commander-in-Chief consistent with the Mutual Defense Treaty, Your Honor. In fact, the President could have simply allowed, right, the construction of runways by United States forces with his Commander-in-Chief powers consistent with the MDT. Like I said earlier, Your Honor, the MDT's second principle is the principle of defensive preparation. Does it make sense for the President to improve our runways? Yes, of course. He can do that as Commander-in-Chief. But we have constraints with respect to our resources. Now, given those constraints, can the President allow, consistent with the Mutual Defense Treaty's concept of defensive preparation, the improvement by the United States of our own runways? I say absolutely. Absolutely. Do you need Senate do you need Senate concurrence for that? No, because that is not a foreign military base. That is not a foreign military facility. This is a Philippine military runway. To the extent that it may be considered a facility, it is a Philippine military facility.
All right, all these things are for free. I think one of the provisions here is that there will be no rentals.
Nothing, Your Honor, is free, right?
Nothing is free. So what was the price
No.
that we will be paying?
It's a rather simple arrangement, I suppose. The United States, because they have an interest in the region, will construct hangars, ports, runways, mess halls for the Philippines for free. For free. They will do that for free. Why? Because they have an interest in using those Philippine areas whenever they visit pursuant to the Visiting Forces Agreement. Right? That is why they don't have to pay rent. Rent is consistent with the concept of a lease. We're not allowing them to lease, Your Honor. What the regime here, I suppose, is we will allow you to improve our bases. We will allow you to construct our facilities, improve our facilities. For that, you get joint use. Every time you land, you can take advantage of these runways that you built anyway. Is that reasonable? I think so. Every time you're here, you can use our barracks. Why? Because you built it, and every time you're no longer here, or once you're no longer here, we can use those barracks. Is that a reasonable agreement? Yes, of course. Pursuant to the MDT's concept of defensive preparation. Why? Because defensive preparation involves the improvement of, or includes the improvement of, our own bases and our own facilities.
Okay, I'll go to another point. You describe EDCA specifically as a framework agreement. What
Yes.
did you mean exactly by that?
By framework agreement, Your Honor, what I meant was this is the basic template for the permission system that we have under the VFA, and which is also the policy of the Philippine government. And so, to clarify further the details of what can be done under the VFA, and to set the parameters for construction activities, right, we are creating this EDCA. And it's a framework agreement because you are creating a range of possible activities. But those activities will have to be pre-approved as soon as the United States desires to perform a particular activity, or as soon as the Philippines desires a particular construction or a particular activity. That is why it is a framework agreement, Your Honor.
All right, my last question is this. Is this EDCA in any way connected with the issue of Bangsamoro?
We have to assume, Your Honor, that all security concerns of the Philippines were taken into consideration when we entered into the EDCA. External and internal concerns were taken into consideration. To that extent, the EDCA is one of the tools that we have, or we can have, for purposes of responding to our manifold security concerns, whether internal or external.
So that means a yes?
It is included, Your Honor.
Okay, thank you very much.
Thank you, Justice Berson.
Justice Reyes.
A few questions. Thank you, Madam Chief Justice. Good afternoon, Mr. Solicitor General.
Good afternoon, Justice
I
Reyes.
just want to be clarified on certain matters affecting EDCA provisions for my own enlightenment. Article 10 of the EDCA states that all obligations under this agreement are subject to the availability of appropriated funds authorized for these purposes.
Yes, Your Honor.
On the other hand, Article 3, Section 6 states that the United States forces shall be responsible on the basis of proportionate use for construction, development, operation, and maintenance costs at agreed locations. Specific funding arrangement may be defined in implementing arrangement. Correct,
Yes, Your
Counsel?
Honor.
Will you agree that a harmonious reading of these provisions means that the Philippines will have to sell out also public funds for the construction, maintenance, development of agreed locations? This is notwithstanding the fact that under Article 3, Section 3, we are obliged to provide the United States with agreed locations free of rental costs. How would you harmonize that provisions, Mr. Counsel?
Your Honor, I think the commitment of the United States here is that they will assist in the improvement of our bases and facilities. To what extent they will assist, the specific sharing between the Philippines and the United States, right, will have to be done through the implementing agreements. If I may provide an example, right, suppose we say we want the United States to construct some barracks and a runway, and the Philippines says, and the United States says, well, we agree to that, but we have limited funding for right now, for those construction activities right now. Is it possible? Is it within the realm of possibility that we can say, we'll make this an 80-40 arrangement, 80-20 arrangement, or 90-10 arrangement? That is possible. But the important part, Your Honor, is that we can allow the United States to construct because we have limited resources. We are allowing them to construct for us because both the Philippines and the United States have an interest in these types of construction. Meaning, Your Honor, that we free up all the amounts of, all the monies that we could have spent for a runway, barracks, ports, right, for the other concerns of the government. And the United States will take the cudgels for that because they themselves have an independent interest in those types of construction. But the specific sharing, because you have proportionate use principle here, will have to be at the level of the implementing agreements.
So I'm correct with my interpretation that the Philippine government will also provide some public fundings.
What is clear, for example, Your Honor, is that we will assume the tax liability for the use of utilities and water, for example. That is very clear. And so it's not a tax exemption, but it's a tax assumption mechanism. And so if the United States uses, or the barracks they have constructed for, say, 30 days in a year, what we're saying is that for those 30 days of one particular year. If they use water and electricity, they will pay for water and electricity, but will pay the taxes. That is the arrangement, Your Honor.
Right, Mr. Solicitor General. It is also your position that the EDCA is an executive agreement. Hence, it does not require the concurrence of Senate. That is the position of the government.
That is true.
Executive.
That is true, Your Honor.
But I noticed that in its press release, number 314-03, dated 26 of June 2003, of the Department of Foreign Affairs, categorically stated that in an executive agreement, there will be no need for legislation to fund the agreement. Can you confirm that, Mr. Counsel?
I will have to check, Your Honor. I don't have a copy right now.
On the assumption that there is such an agreement, do you think that is this not directly anathema to Article 10 of EDCA, which specifically provides that all obligations under this agreement are subject to the availability of appropriated funds authorized for these purposes? That is, if we assume that indeed...
Yes, Your Honor. And in fact, that is one of the ways by which Congress can exercise its check on the executive department. On the assumption that the Philippine government decides to assume a certain portion of the construction, the funds for the construction activities, that liability, that obligation on the part of the Philippines will have to go through the ordinary budget process. And that is a way by which the legislature can, in fact, exercise its power to agree or disagree with the EDCA.
Clarificatory question, Mr. Counsel. Would you agree that the EDCA itself is self-executory in the sense that its implementation need not be prompted by any further arrangement?
Your Honor, it is self-executory insofar as no legislation is anymore. But to the extent that there will be implementing agreements for the specific activities and the other mechanisms under the EDCA, I suppose it's not self-implementing.
From the very provision itself of EDCA, more specifically Article 10, Section 2, it appears from the language of that provision that the enactment of additional arrangement is a choice rather than a duty between the parties to the EDCA or their designated authorities. Would you agree with that?
I agree, Your Honor. I suppose there are two ways to implement EDCA. If they want to go down to finer details, they can enter into implementing agreements. But they can also do this on a per activity basis, which is the function of the MDB and the SEB. And so all activities under the EDCA can be done through the MDB, SEB consent mechanism. Or if they want, they can create substructures for implementation through implementing agreements.
From my own reading and research, under Memorandum Circular Number 89, issued by the Office of the President, that is way back in 1988, in case of conflict as to whether an agreement is a treaty or an executive agreement, the legal advisor of the Department of Foreign Affairs and the Assistant Secretary on Legislative Affairs and the Senate will be given opportunity to comment on the nature of the agreement. Consultations shall be made with the leadership of the Senate. The Secretary of Foreign Affairs shall make the proper recommendation to the President. In fact, in 1997, an executive order 459 was issued, and under Section 9 thereof, the Department of Foreign Affairs determines the nature of an agreement. My question is, were these procedures complied with before the EDCA was signed by the Secretary of National Defense?
I have to assume, Your Honor, that under EO 459, the Secretary of Foreign Affairs had made a declaration that the EDCA is an executive agreement.
All right, thank you very much, Mr. Solicitor General.
Thank you, Justice Reyes.
Mr. Solicitor General, have you read the agreement establishing the Mutual Defense Board?
Yes, Your Honor. Yes, Your Honor.
What about the agreement to establish a Security Engagement Board?
It's in a note, Your Honor.
Yes?
Yes, Your Honor.
Yes to both agreements?
Yes, Your Honor.
Will you be able to provide a flow chart for the court to understand the so-called consent mechanism that you have been describing, to say that therefore the context of the agreed uses here under Article 3, Paragraph 1, as well as the other activities that is in the same paragraph, which is in the in the very last phrase, shall be subject to the process of the SEB and the MDB. And that you will be able to prove to the court that this is in fact a prior consent mechanism by Philippine authorities.
Yes.
Okay.
We can provide that, Your Honor, in
The
our
flow
memorandum.
chart, of course, the agreements themselves shall be in your memoranda.
Yes, Your
memorandum.
Honor. Yes, Your Honor.
Okay. So this is in connection with the questions of Justice Velasco, whereby he is asking that it be established in fact that there is operational control, not in the sense of military operational control, but control in the sense that consent is required.
Okay. Yes,
Okay.
Your Honor.
As well as the manual that you were discussing, where you were discussing actual military operations and the right of military forces when attacked.
Yes, Your Honor.
Okay. Will you also kindly please provide us a matrix that will describe for each activity in the EDCA and each concession granted by the Philippines to the United States, whether it falls under the President's Commander-in-Chief powers, administrative powers over the Executive Department, Foreign Affairs power, so that we are fully
Yes.
falls within.
Yes, Your Honor, we will provide those.
As you can
matrices.
sense, there are some justices who have already also looked at the possibility of a declaration of either a partial validity or invalidity. Okay. Now, with respect to the VFA, have you read the counterpart agreement of the VFA, which was signed in October 1998 regarding the presence of Philippine military troops that are going to visit the United States of America?
Yes, Your Honor.
Are the concessions that are being granted to the U.S. forces under the VFA for U.S. forces visiting the Philippines also granted to Philippine troops that are visiting the United States under the agreement that was signed in October of 1998?
Yes.
Were they granted also?
Okay, we will provide a comparative matrix in our memorandum.
Yes, because this is in connection with the question of Justice De Castro,
Yes.
that in fact the VFA allowing U.S. forces to visit the Philippines is just a lopsided agreement. Now, I note that there is an agreement, on the other hand,
Yes.
for Philippine troops that are visiting the United States. Can you make a comparison?
Yes, Your Honor, we will do that.
Now, will you also look at, please, the question of taxation, whether it is a tax exemption or a tax assumption? What are within the exemption powers and what are the under the assumption powers, and what is the authority of the President to authorize exemptions, and how it interplays with the constitutional power of the Congress to grant tax exemptions?
Yes, Your Honor, it's clear that it was a tax assumption provision, but we'll provide you with a more
Legal
detailed
basis and
explanation.
authority.
Yes, Your Honor.
Okay. I also want to find out in what instances the President can grant anyone the right to operate telecommunications without making it go through either a legislative franchise or an administrative franchise.
Yes, Your Honor. Our answer, Your Honor, is rather straightforward. The radio spectrum is will be given by the AFP, and so the United States forces will not be operating a public utility. Only a public utility requires a franchise, Your Honor. The United States will be operating, will be using the radio spectrum not to operate a radio station or to
Not
to play the
engage in any
latest.
mass media activity.
Yes, Your Honor. It's not for Taylor Swift songs, Your Honor, but for purely military purposes. And so what we're giving, Your Honor, is what the AFP already has. And that is clear, Your Honor, under the statute, that the AFP is exempt from the franchise requirement.
Are there other executive agreements whereby the President, in implementation of that executive agreement, authorizes a foreign party to build facilities?
Okay, we will look for those agreements.
I want
Your
to
Honor.
find that out, because I want to find out the extent of the legal authority of the President to authorize the building of facilities on Philippine land.
Okay.
Now, with respect to the Golan Heights incident, where our Philippine commander did not recognize the instruction of the Indian commander of the UN peacekeeping forces to stand down and to surrender, what was the concept or the nature of that disobedience? In other words, should a Philippine commander tell a US commander to stand down, what will be the consequences of such a command?
We will provide a more detailed response in our memo, Your Honor.
Okay. I have, right now, I have no further question, but I think Justice Leonen has a few more questions regarding some issues.
By the way, Solgen, is the VFA administrator in the session hall today?
I do not know, Your Honor.
I see General Oban, who was chief of the Philippine Air Force and also the chief of the Armed Forces of the Philippines at one point in time. I just wanted to say that because I think many of us in the court recognize the gallantry and sacrifice of our Filipino soldiers. And the trend of any of our questions does not mean to denigrate the capability and the capacities of the armed forces. I just wanted to say that.
Thank you, Your Honor.
Okay. The opening line in Von Clausewitz's classic on war is that it says that the ability to do war is an extension of foreign policy or political policy. Are you familiar with that line?
Yes, Your Honor.
Because I want to go into your theory, and that your theory is everything here is part of the President's power as Commander-in-Chief under Article 7, Section 18. Is that not correct?
Correct, Your Honor.
Yes. But as Commander-in-Chief, of course, the President has to take care of internal conflict, and therefore he has the power to call out the armed forces, declare a state of martial law, suspend the privilege of the writ of habeas corpus, among others. Is that not correct?
Correct, Your Honor.
But then on the other hand, his power as a Commander-in-Chief with respect to the declaration of a state of war is shared with Congress. Is that not correct? Article 6, Section 23, the power to declare a state of war is with Congress, and there is a specific method of voting in terms of Congress. Is that accurate in our Constitution?
Your Honor, there are complications with respect to the power
But
to wage
that
war.
provision exists, which means, therefore, that the power of the President as Commander-in-Chief is shared in relation to the power to make war. Of course, there is still the other provisions that curtail or frame the power of the President. Article 2, Section 7, that we should conduct independent foreign policy. Article 2, Section 8, nothing about nuclear weapons, etc. Now, when the President deals as Commander-in-Chief with foreign military forces, therefore, it is not only the Commander-in-Chief provision that is involved, but likewise the creation of foreign policy. Is that not correct?
That is correct, Your Honor.
And therefore, there is a specific provision in the Constitution which actually frames the power of the President to act as Commander-in-Chief in the international arena, and that is Article 18, Section 25, as earlier mentioned, correct?
Well, to some extent, yes.
Yes, and this court is tasked, or our duty in terms of judicial review, is to do the bidding of the sovereign Filipino people expressed through the Constitution, not by the vote of the President, but as what the Constitution says. Is that not correct? We
Correct.
allocate the boundaries of power. Is that not correct?
Well, you have to have a case, Your Honor.
Yes, with all the qualifications of justiciability and jurisdiction, of course.
Yes, Your
that
Honor.
is part of judicial review. So the question before us, as we have always been telling you, is whether we interpret Article 18, Section 25, and how we interpret it. Correct?
Yes, correct, Your
Yes.
Honor.
And part of it is looking back at the history of the negotiations. Of course, many of us having been negotiators at one part of our lives, in deliberations we negotiate among ourselves, it is very clear that there is such thing as constructive ambiguity in the terms. Is that not correct?
Correct, Your Honor.
That you have a term like, for instance, operational control, that means something for the Philippines, and you cited the Philippine Air Force dictionary, but it also means another thing to the Department of National Defense of the United States in its manual of 2010 as amended recently in August of 2014, and I flash it there. This is the definition of the United States of operational control. There are differences with respect to the Philippines, but in essence, it is the control of subordinates, correct?
In fact, Your Honor, that is a good definition of control.
I won't concede to the U.S. immediately. I think the Philippine Air Force, in spite of its assets, are very good at language.
At defining
Because
things,
that
it's
may
possible,
be
Your
their
Honor.
weapons, in any case. So if you notice, operational control also indicates the definition of a mission designating objectives, the command and force, as well as assigning the task. Is that not correct?
Correct, Your Honor.
So when we say that the United States, in the article cited by Justice Velasco a while ago, that they have operational control this is in Article 6, Section 3, which was cited by Justice Velasco a while ago. It says there, operational control or defense, including taking appropriate measures to protect, etc. Okay, this is Article 6, Section 3. It means that they task with an objective, with material and men, as well as the allocation of forces, their own troops, in order to accomplish an objective. Is that not correct?
Yes, Your Honor, but that
Okay,
objective
now,
will have
notice
to
the
be...
second sentence. The second sentence says, coordinate such measures with appropriate authorities of the Philippines, correct?
Yes, Your Honor.
And from here, you derive your concept of consent. Is that not correct? As you
Correct,
said,
Your Honor.
the agreement is littered by qualifications that the Philippine government consents. Now, let's go to the 1991 treaty. And in the 1991 treaty, it is worded this way. Notice, subject to the prior approval of the government of the Philippines. Again, we flash back to the EDCA provision. In the EDCA provision, it says coordination. Of course, we are Filipinos, we know English. We know that there is a difference between approval and coordination. For instance, the United States can call the designated authority before wheels up, which means before the plane takes off. But they have already tasked, they have already defined the mission. And coordination, therefore, will have to be defined between the Philippines and the United States, furthermore, correct?
Correct, Your Honor.
Yes. It is not like in the 1991 treaty, the negotiators there, because of the political climate and because of the fact that they knew that they were going to the Senate, were able to wangle a stronger word. And the stronger word was approval. Is that not correct?
Well, with your permission, Your Honor, I hope to return to what you showed earlier with respect to the provisions of the 1991 agreement. The 1991 agreement, Your Honor, is very specific, projecting or operating United States forces from installations under conditions of peace of war, provided military combat operations directly launched from installations shall be subject to prior approval. This is
So
combat
are you saying
operations.
that in the EDCA, the U.S. forces that will transit here, assuming that they indeed will only transit, will not be used for combat operations?
They can be used for combat for defensive
Thank you.
purposes.
Yes.
Defensive, Your Honor.
Thank you. That they can be used for combat for defensive purposes, which brings
If
me
they
to
are
my-
attacked.
Which brings me to the next point. Okay. The Charter of the United Nations, as we have raised during the interpellation of the petitioners, contains a provision on self-defense,
Yes.
individual and collective. Is that not correct?
Correct, Your Honor.
Okay. So, therefore, in 1967, Israel conducted the Six-Day War with Egypt. And the theory of their military action in law, the use of force, I'm not going to ask about the military operations, I'm going to ask about the legal cover, was preemptive defense. That was the same in 1975 when Israel, Palestinian camps in Lebanon. And in 1981, when they also bombed the Osirak nuclear reactor in Iraq. And then, of course, in 1990, the United States in Khartoum banned Al-Shifa pharmaceutical buildings. This was in the concept of a preemptive action. Of course, they used men and material in doing so. So this is preemptive attack, and the US is seen as having used this very concept in history. The other one is, let us say, the 2003 Iraq operations of the United States in 20 March of 2003. Their theory of defense and their theory of the use of force, and their interpretation was this was part of US versus Nicaragua, was because they wanted to do self-help. And then finally, the NATO invasion of Yugoslavia recently, because of the international humanitarian law violations in Kosovo, and this was humanitarian intervention. Now, the thing is that when we put military troops into our country, there are possibilities that we will be drawn into armed conflicts of certain kinds. Maybe not war, but certain kinds of armed conflicts that shape our foreign policy. And if we say that there is in the Constitution some leeway, that this is not only the action of the President, the people commanded, that it should be also determined by the Senate as representatives of the people, because two departments are better than one. The 24 senators may have different minds, but these are different minds of the Filipino people. Then therefore, would you not say that the better approach to interpreting Article 18, Section 25, is that we should be liberal in these types of agreements like the EDCA, to weigh in favor of giving it to the political department rather than to the Supreme Court of the Republic?
Your Honor, let me just respond first to everything that you said about the concept of defense. That is entirely different, because the defense there is the defense of the state. The defense that we're referring here to the EDCA is the defense of the troops if they are attacked. Say, for example, during an activity.
Yes, I understand
so-
that there is such a difference, but we are working in a real politic. I mean, the United States is not here just to defend their troops that are put in our agreed locations. The United States is here because we are in their, they call it the depth of defense, right? That we are in the rim of the Pacific, and they see that putting advanced troops here either would change the political conditions of the relations with China and many other countries here, as well as, of course, partly they would want to operate. Is that not correct? Or are you saying that they're just here for purposes of building airports, of putting in bunkering equipment, etc.?
I think, Your Honor, if we would like to stick to the constitutional purposes of the EDCA, we can imagine and speculate that the purpose of the United States is to project their power and to assist us in maintaining
That's the
minimum
point.
credible defense.
We are asked to imagine the political consequences of all of this, where the
But-
people have said that the way to project this and to deliberate upon it is that the President goes to the Senate and the Senate will check on the premises of the President. Let me show you one other thing. This is from a CRS report in the United States. And I lifted these paragraphs in a CRS report in 2012. Okay, here is the United States Congress telling themselves what they will do with China. And here they see that the Chinese People's Liberation Army is now taking advantage of a window of strategic opportunity to advance China's national development. But then it recognizes, next paragraph, that they need to relate with them in terms of military exchange as well as in terms of their economy. And we know for a fact, perhaps, that the Chinese and the United States economies are very much intertwined. Now, these things are political considerations, correct?
If I may, Your Honor, there are two institutions of government that have special
Yes,
expertise.
but these are political considerations,
The
correct?
DND and the DFA.
I'm sorry, but I'm asking the question, and I hope that you can be responsive. These are political considerations, correct?
Yes, Your Honor.
Yes, and you are now asking this Supreme Court to make a ruling on EDCA, and you want it to be a binary ruling, whether it is constitutional or unconstitutional, with us not being equipped with all the national security considerations that went into this. And we see an out in the Constitution. The Constitution says that the political leaders in the Senate, being nationally elected individuals, and 24 of them from 15 of us, would be better equipped, according to our people, to see the other considerations that go into this particular treaty. So, Mr. Solgen,
If I,
don't you think that it would have been a better forum for the President of the Philippines, who is a political leader, having more influence in the Senate, to go to the Senate rather than wade our fortunes in terms of national security in the Supreme Court of the Republic?
okay, thank you, Justice Jonan. If I may, Your Honor, there are two important offices within the Executive Department that have full expertise on these matters: the Department of National Defense and the Department of Foreign Affairs. They have the technical expertise, they have the institutional memory, they know what they're doing. They are within the Executive Department, Your Honor. They're within the Executive Department. And
But,
so,
excuse me, the military is always under the control of the civilians.
The
And this is
President.
doctrine. This is the Constitution. And if the military can explain to the President, they can also explain perhaps to the senators in camera the considerations of this foreign policy and these potentials for aggressive or defensive action internationally. So again, don't you think that this should have been sent to the Senate?
if I may, Your Honor, I think, Your Honor, the question here before us is rather clear. And the question is, are there existing licenses for what the President
I'm sorry,
has
Solgen,
done?
but you just ignored my line of my question. My question is, don't you think it would have been better with the Senate?
Your
I mean, you
Honor,
already
I
made
will
your
answer
argument
it.
a while ago, and we gave you a full 30 minutes, and this is the time that we inquire because we want to be informed in terms of our decision making. So my question is, don't you think it would have been better that the Senate become involved?
No, Your Honor.
Okay. Are you familiar with the JSOTF?
JSOTOFP, Your Honor.
Yes. They had facilities owned by the Philippines inside military bases, correct? Camp
yes, Your
Navarro, Camp Awang, etc. I can enumerate most
Yes,
of them.
Your Honor.
Okay. They were already operating under the BFA. Is that not correct?
That is correct, Your Honor.
And my question is, if they were already able to operate under the VFA, why is it that we still need EDCA? The JSOT was at one point, they were in the hundreds. These were
Yes, Your Honor.
warm bodies
Yes, Your Honor.
who did training on our military. We have a light reaction battalion that is the envy of, I think, a lot of armed forces in Asia, because what we do not have in material, we make up for the ingenuity and the skill of our people, be they pilots or be they Marines or be they infantry. They were able to train them. The JSOT was also,
JSOT of Your
yes, also instrumental in counter-terrorism activities. They provided the material, the drones, the technical equipment to gather intelligence, but of course nothing can substitute for the human intelligence that was provided by our troops on the ground. So my question is, this was already available under the VFA. My question is, why was there still need for an EDCA?
Thank you, Your Honor. In fact, one of the reasons for EDCA is so that you can clarify the relationship between Philippine and U.S. forces for situations such as JSOT-P. I think the experience with the JSOT-P was that there wasn't much clarity in the way the American forces were operating. And so there were questions. But I remember that Congressman Biazon, who was head of the legislative oversight on the VFA, visited there and he saw nothing. He didn't have any problems. And so the EDCA, in fact, is an occasion for the Philippine government and the United States government to clarify their relations when it comes to specific activities under the VFA. And I don't see anything wrong with that.
Finally, Mr. Solgen, can we declare that this petition is premature in the sense that the EDCA is an agreement and it is a valid agreement but not enforceable until it is passed on as treaty?
Your Honor, I don't have operational control over the Supreme Court. The court can craft remedies and reliefs, and it has plenary powers to do what it wants to do. Whether that is the right thing, whether constitutional law experts and law professors and law students will agree with that relief is an entirely separate matter. But that is the choice of the court, Your Honor.
May I ask one last question? In one of your articles on popular constitutionalism, you mentioned that the political departments are better at resolving these types of issues. Have you changed your mind?
No, in fact, Your Honor, the proper political department here is the executive department because he is the commander-in-chief. And again, Your Honor, I will exhort the Honorable Court not to diminish the power of the President as commander-in-chief right now. We need it to be as potent as it can be right now. Thank you, Mr. Justice, Your Honor.
Justice De Castro, I just want some clarification, which you can put in your memorandum.
Yes, Your Honor.
You are invoking the BFA. Now, that was submitted to the Philippine Senate, no, for concurrence. On the part of the U.S., it was not.
Yes.
Will you explain why the U.S. considered this agreement, this BFA as a binding international agreement insofar as the U.S. is concerned? Together with the EDCA also, why is there no need on the part of the U.S. to submit this to the
Senate
US,
for concurrence.
the U.S. Constitution uses a different language, no?
Yes, sir.
Insofar as the participation of the Senate is
Consent
concerned.
and advice. Your
So,
Honor.
did they explain to you, to the Philippine side, why they consider this as a binding international agreement? Now, you just include that in
Okay.
your
Yes, Your Honor.
memorandum
We
because
will.
you accepted that there is no need for the BFA and the EDCA to be submitted to the U.S.
Yes, Your Honor.
Senate for concurrence. Now, I'm looking at the counterpart visiting forces agreement signed by the U.S. insofar as Philippine military troops and civilian component are concerned when they visit the U.S. And there are some tax exemptions here, although the counterpart agreement is not exactly the same as what
That
we
is
have,
true.
no? In our case, there's no concession waiver of criminal jurisdiction.
Yes.
The visa requirements are different, although there are some tax exemption. And I noticed that there is a provision here in the one on the part of the counterpart U.S. agreement, where there is a need for supplementary arrangements for the implementation of that counterpart agreement, visiting forces agreement signed by the U.S., which may be concluded as required between appropriate authorities of the parties. Will this mean that there's no automatic entry into force of the agreement? Is there a need for supplementary arrangements for this? And what is the basis for the authority of the executive department to enter into this agreement for the government of the USA without Senate concurrence?
We will include everything in our memo, Your Honor.
There might have been some prior legislative authorization
Yes.
for the U.S. President to deal with matters concerning security or dealings with the armed forces of other countries.
Okay, Your Honor.
So
We will
please
include it.
include that in your memorandum so we can find out why this agreement, the VFA and the EDCA, are considered binding agreements insofar as the U.S. is concerned.
Yes, Your Honor.
There being no further questions, the parties' counsel will please stand. The Solicitor General may please return to his seat. The parties are given 20 days, non-extendable, to simultaneously file their respective memoranda, causing them to be first served personally on the other parties, after which this case will be deemed submitted for resolution. The session is hereby adjourned.